suppressed. None of it can enter the trial. The jury cannot hear anything of it. And, you've charged him with all these counts, but the counts that you charged him with in the indictment, they're based on the evidence. They're based on that poisonous fruit. They're based on the evidence. So not only does not all that evidence come in, but all of these charges need to go away as well. Now, we're not sure. There's so many charges. We're not sure exactly what charges they want tossed and what they do want versus what they don't want tossed. They want them all tossed, to be honest. But what they're arguing should be tossed. And again, we're just waiting for them to come back into the courtroom. But that's the argument. The state is saying, no, we'll listen. This evidence, this case might have been bad, but there was other cases that we had based on the evidence that we got. So now that we got all this fruit, we started new cases, and these new cases, they're ongoing. So we need to keep the fruit for the new cases, the new cases that we had. Still, and the judge is saying, yeah, you got the new cases, but though you never would have had those new cases if you didn't use the poisonous fruit in the first place.
Exactly.
Right? So you got to toss out everything. And so that was the tension there. And the state the judge was like, I agree with Brian Steele. I agree with Young Thug's attorneys. And the state was like, well, we don't agree. So the judge has taken a 5-minute recess and is going to kind of decide how he wants to rule on this. All right. And, there are Young Thug is in the courtroom. There are about, are you not on this? And this is an interesting
view. I like that view sometimes. I use this on my stream, but just by myself. It's a pretty good one.
Yeah. So we're still waiting on the judge to come in. Yeah. You can't see it. You can't see it right now, but before court started, before the judge came out, you saw all of the defendants. They brought in about 15 defendants. There are 3 counsel's tables in the courtroom, one for the prosecutor, one for Young Thug, and then one for another defendant who I don't recognize. Gunna, as you guys know, pleaded guilty and was released yesterday. He got time served. He had been incarcerated under these charges since about May or March of this year. And it's December now, so he served some time. And most people thought that he didn't really do anything anyway. Most people thought he was not a gangster. He was not really YSL. He doesn't rap about killings. He doesn't rap about this. He's more rapping about the women. He's more rapping about the Versace, the clothes, the jewelry. This ain't him. So everybody feels pretty much that this is a just result, but they are wondering, how did you get that plea offer? Everybody else is in jail. Everybody else is fighting. Did you have to turn state's evidence? Did you have to make an affidavit? Did you have to give evidence, any type of testimony against your 28, 29, 30 co-defendants, right? So we're still trying to work this out. Now, no one was expecting him to plead guilty to this yesterday, and no one was really expecting this hearing today. So we are in here and we're trying to figure out what's going on. Is Young Thug going to plead guilty today? There is some motions hearings. He has not indicated any type of plea. They're arguing about the suppression of evidence. Guys, suppression of evidence can make or break a whole case. It is such a big deal. If I commit a murder, but I get the bloody gloves suppressed, I get the CSI information suppressed, I get the knife suppressed, it doesn't matter what I did in real life. It matters what you can prove in court. And if I did a murder in real life, but you can't prove it in court, then I didn't commit that murder. I'm innocent until proven guilty. So a lot of times I'll tell you, you guys know, if you don't know who I am, mucho gusto. I am the lead attorney. This trial is happening right down the street. I'm here in Atlanta. I've practiced in front of Judge Glanville many times. He was in his old courtroom when we started this up, and I've been in that courtroom countless times. I've never been in this courtroom.
for the court's consideration, D1 through 10. Within those documents was the order Judge Newkirk entered. Can I have those, Christine? Do you have those? Do you have those ones? Are they up here? Okay, hold on a second. Okay, hold on. No, let's see. Thank you. All right. All right. D1 was the accusation that was filed in this case, and that was related to the possession of marijuana charge. D2 was the motion to suppress any and all evidence located from the defendant's home. D3 was the supplemental motion to suppress any and all evidence located from the defendant's home. D4 was the order granting supplemental motion to suppress any and all evidence. And it reads as follows. After hearing testimony, a stipulation of testimony, and argument from the parties on Monday, April the 3rd, 2017, this court hereby grants defendant's supplemental motion to suppress any and all evidence located from the defendant's home. Based on this ruling, the evidence located in defendant Williams' home is subject to the above referenced accusation number 16 SC1, and there are 6 fours. Specifically, that just over an ounce of marijuana, it is hereby suppressed and cannot be used in evidence by the prosecution in the trial of Jeffrey Williams, signed by Henry Newkirk on the 10th of April, 2017. There was a motion for reconsideration that was filed or accepted by the clerk's office on the 20th of April of 2017. There was an order, that was D5. D6 is there was an order by Judge Newkirk entered on the 24th of April, 2017. The order, it reads as follows. The court having read and considered the state's motion for reconsideration, the same is hereby denied. D7 is a motion for null pros on the same case where Mr. Steele filed a request to have the accusation null pros. D8 is the dismissal for want of prosecution. When the case was called for trial, the state was unable to proceed, and Judge Newkirk has the following reason: the motion to suppress was granted, and he granted the motion to suppress, and that was the 3rd of April, 2017. There is a exhibit from our last hearing on the 17th, D9, which is a letter that was written by Mr. Steele to Mr. Charlie Bailey, Esquire, May 17th of 2018. The state of Georgia versus Jeffrey Williams, accusation 16 SC1 for 44444. Dear Mr. Bailey, I hope all is well with you and your family. I'm writing you to pursuant to my representation of Mr. Jeffrey Williams in the above referenced case. As known, the Honorable Court suppressed all the evidence in the case was null pros and prosecution is ceased. Mr. Williams has been attempting to obtain his property that is lawfully his concerning the above referenced case. The city of Atlanta is not releasing the same, as they still have the same marked as evidence according to Mr. Williams' father. Could you please assist in having the property released to the lawful possession of Mr. Williams or his designee? Please call upon receipt to discuss the above. I look forward to speaking with you soon. Signed, sincerely, Brian Steele. Copies to the 2 Williams, one being the defendant, one being the senior, his father. D10 is the warrant for search and seizure. And those were the 10 exhibits that were admitted for the court's consideration on the motion on the 17th of November. So the court's concern is that while you all, the state that is, think that Judge Newkirk just specifically exclude the marijuana, he did, but the legal premise behind it would be fruit of the poisonous tree. Anything that was taken in that house at that point in time would be subject to being suppressed. And that's the first thing I'm going to let you all address. The second thing that would be of note is that under 17-5-30, this property was requested to be returned. And the statute's pretty clear, shall not be used in a future criminal prosecution. That is different than the return of property statute during trial 17-5-54. So, yeah, that's why I preface this. I've had an opportunity to take a look at Judge Newkirk's transcript, which will also be included for purpose of the record, is the next court exhibit from the 3rd of April of 2017. So with that, Ms. Love, what say you and your colleagues?
Yes, Your Honor. First of all, Your Honor, understanding the court's review of the transcript, I want to point out that in ruling on evidence that pertained to the possession of marijuana charge that Mr. Williams faced in that indictment, the court specifically, during the course of the proceedings, clarified during an exchange with the prosecutor, he is only seeking to suppress the marijuana.
I agree with you that, but the legal premise would still hold on anything that was taken in that home by a search warrant. You had an arrest warrant issue, and then you had a search warrant issue. So if Mr. Steele challenged the arrest to begin with, the warrant or copies of the arrest warrant and the warrant under Baez, versus the state, which is a 206 Georgia 552, which he cited at that point in time. That would make it so that anything else in the house that was taken would have been subject to being suppressed. Mr. Steele amended his motion. He asked for everything.
By copy of the county ordinance, and the Honorable Court of Appeals of Georgia found that the odor of marijuana was sufficient probable cause. The police then could search the car under the automobile exception. The backpack then, therefore, should be searched. The contraband inside the backpack should not. In Court's Exhibit number 2, so Alford is like a waste. Respect, I don't mean to be rude. It is just not even close to what we have here.
Can I hijack you a second, Mr. Steele?
Of course.
We're going backwards. We should be going forwards. That I agree with you at the status of your hearing in front of Judge Newkirk. The issues involving the search warrant, the arrest warrant, the search warrant, and these issues would have been. It's a snapshot in time. Since you filed another motion to suppress, the state now is willing to at least present forth evidence to show that the arrest warrant, the search warrant, and the seizure of these particular items, that there is a basis, because we've gone forward and it's another case. So can you address that for me? Because I don't believe that I have to kind of look at it from my.
Kent, what up? My boy Kent.
What's good? I'm just listening, trying to hear it.
Yeah,
so
we just, you know what I'm saying? We just getting up in here, man. I thought this was real interesting, man. They talk about the suppression of evidence, and a lot of times, man, though, with the law, they just go in there and grabbing shit, man. That shit has to be legal, man. I think people need to focus a lot on their constitutional rights.
You gotta know them.
That shit is huge, man, because if they getting evidence, so that's what they talking about, man. It's kind of crazy, and I thought I was looking real bad. Well, I don't know what it's going to turn out, the outcome, but for Young Thug and everybody, but they are making some hell of a arguments, man. I'm gonna just we'll chime in here and there, but just keep it going.
Foxhole, because
definitely learning.
This evidence is related to, you filed a motion to suppress in this case. So I can't rely totally upon what Judge Newkirk has indicated. And also, this case was never appealed, so there's no really appellate ruling on this issue. So I would argue it's ripe to consider again.
I would respectfully disagree. I wish I could do that in every case that I don't win, that I can come in and do a second bite at the apple. This is the exact
But it's a
issue.
different case.
No, it's, so then the state can just, I win a motion to
No,
suppress?
it's a different, okay, it's a different case. That was just a possession of marijuana case. This is a RICO case, and they're arguing at this point in time, since you filed another motion to suppress, that we look at probable cause and the other things from the vantage point of 2022.
Your Honor, I filed a motion to suppress based upon the law of the case. It's a final order. It was not appealed by the state of Georgia. It is a final order. It doesn't matter. It didn't go up to the appellate court. And it is the same issue that's already been litigated between the same parties, Mr. Williams and the state of Georgia. They're still the state of Georgia. It is res judicata and it is collateral estoppel, and all that is in my motion to suppress. Also, it is not accurate to say that Judge Newkirk did not consider fruit of the poisonous tree. Judge Newkirk considered the following. My motions, which are in front of the court, the original motion and the supplemental motion, challenges everything that was taken from Mr. Williams' home.
Your motion to suppress is D2, and your supplemental motion is D3.
And it challenges everything that was done because the police unlawfully, as found by the Honorable Judge Newkirk, entered Mr. Williams' home. So what happens at our hearing, specifically at transcript,
let me see.
page.
So basically, you know, when they say bad fruit of the tree, they're saying that you know, like just like if they lie and you catch them lying and they use that lie to get a search warrant, then everything that came, all the evidence that came after that lie is supposed to get suppressed. So it's supposed to get thrown out. So if that's the evidence in the case, it doesn't matter if it's a murder case, it doesn't matter. If there was something that, you know, is tainted, you know, they used to get a judge to get a search warrant on this house. Let's say they're lying and saying that they had an informant that didn't exist or something, and then they use that.
I thought they would have to provide like some type of evidence to the judge to even get that, to get a search warrant, right?
Yeah, but they lie. They lie. Just like I said, let's say they go to the. I'm in a situation where there was a lot of fabrication, and then I have a surveillance camera that shows that, yeah, this is rather exaggerated. So the judge will have time to think about, you know, of course he has to rule on it, but it's up to him to be like, okay, well, yeah, this isn't legal. That's against his constitutional rights, because you can't use false statements to obtain a search warrant. You see what I'm saying?
Okay, but the judge itself, though, they have to do their due diligence as far as validating what's being brought to them for him or her to determine.
Yeah, but it happens though. It happens though.
Mm-hmm.
It happens all the time. I feel you, but the judge, you know, they only know so much. What up, Chef?
Man, what's good, Doc Hood?
Oh man, you know what I'm saying? We just digging, algorithm surfing.
I love it. That's what you do, man. You chop it and pop it and dissect it and make sure everybody understands it. So what you doing, man, you're really helping my people. I can't tell you that enough, right? Because, you know, sometimes, nigga, we don't agree on everything, but at the end of the day, the conversation's being had in a productive way, and that's more than I could say for what we normally do.
Right.
Yeah, so,
right.
You know, yeah, this shit, but what you talking about, though, like, it's an interesting situation, because I know how this goes, this conspiracy shit, and they'll get a hold to a motherfucker who you're not really one of those, but we could just make things crumble. We could make things look a certain way. And that, man, hey man, we up against some people. When I say we, I'm talking about, if you know, anybody who would be involved in this situation.
Right.
You up against people who they're more fed than you are gangster or criminal. Like, y'all are part-time. You niggas is part entertainers. You niggas is dads. You niggas is activists someday. Nah, these feds, that's what they do. These feds don't be soccer dads and nah, bro, I'm 24/7 with this. I'll miss my kids' game. My kids is just my legacy. My job is my everything. I have nothing better than to put pressure on you every single day. And niggas got to understand, man, a person, they got way more resources. You know what I'm saying? So, and then once they get you, you know, we niggas, man, we don't really care what happened. We care how it look. I'm that way. I'm not gonna lie, bro. Knowing what I know, I'm that way. If it looks like you told, that's what I'm gonna say, bro. Without really doing no research. It's so ignorant, bro. But that's what I'm gonna do, my nigga. Because that's what I've always done.
Yeah, Sweet Diva. It's kind of conflicting. I'm gonna get back into it. I mean, they have some hella arguments. I don't know, man. It's real dicey. You know, we can listen to the verbiage and everything, but it all goes down to the both of their arguments, and then what the judge is gonna rule, and you know how that goes. But he seems pretty fair. He seems like a straight up and down judge, black guy. You know, oh no, we know what you're talking about, Sweet Diva. Don't worry about it. You know, we up in here though. Hold up.
So okay, all right. So tell me this. Go ahead. Now, because now I'm gonna ask. See, I love this part. Now I could go to the experts. Dr. Hood, what did?
Man, I ain't no expert. I had my run-in.
Well,
I had my run-ins with the law, and I've been in a lot of courtrooms. Hey, put it this way: I've been in more courtrooms than weddings. Put it that way. I done talked to a lot of legal beings. You know, walking the yard.
You putting that disclaimer out there right away?
Yeah. Just before you.
Well, we understand each other. My question is, what happened? I don't care what they told me, because you know me, nigga. I don't believe necessarily what they tell me. Why would the fuck you tell me the truth? Who the fuck am I for them to be honest with me about something like this? But let me talk to somebody who knows about these things, who, my nigga, look, I'm just gonna tell you what it is, bro. You could either drink the water or discard it, but I'll tell you the truth about the quality. So this is what I'm asking you. Just from your being Dr. Hood, what is it when you plead guilty to conspiracy and get released, bro? Like, I've never seen anything like this.
Oh, that's time. He got time served. If that's the amount of time, let's say I was locked up for a year.
In the feds. Wait, no. Was it what? Is this a federal case, right? Or is this a state case?
That's what I thought. I thought it was a Fed case. A RICO case.
I'm so, bro. See, Dark Kent, I so don't know nothing, bro.
I thought this was a Fed case. They were facing federal charges, and usually when they come down on you like this, man, they usually got hard, concrete evidence on you.
But
you know what I'm saying?
But with the feds,
they still got to go through with the right procedures, and they still have to make sure all their ducks are lined up. That's what a good lawyer is for,
right?
Because the prosecutor is going to just try to push all the paperwork. They're just pushing the paperwork through.
But they ain't
a
gonna
good lawyer is going to be like, wait a minute, this you can't do this, you can't do that. You know,
but they ain't gonna waste their time though, too. And I've never been in the courts like this, but they ain't gonna waste their time coming at you if they ain't had a very strong case. And it can take them years to build up something really concrete to really know that they can, you know what I'm saying, they got you. So
yeah, but that's still your for your lawyer to argue all the little points.
Yeah,
Even if this little point is irrelevant to the overall trajectory of the case, and it just only gets a little bit of shit overturned or whatever, or nothing. If the judge denies everything,
right.
He's still like, because I don't know the full details of everything. You know what I'm saying? Like, if he's facing additional charges, is this just because what it sounds like to me is that he got pulled over and there was a backpack in the car and it had marijuana and maybe some other type of drugs or whatever. They had open container. So they're trying to say that, there was nothing that said you couldn't have an open container in the state of Georgia, but they smelled marijuana from a distance, so that they were able to use that as the probable cause. Then somehow they got to this man's house, and then they're checking the validity of that, and somehow they got up in the man's house. Now they got his computers, they got all this other stuff. So what the lawyer is there, and even though they might have got a dead body, the lawyer is gonna try to stop it in its tracks. Like, hold up,
right.
For you to come up in that house, you needed this, this, and this. So he's gonna try to attack that. And he knows that what they found. We're not denying about what they found, but you can't use bad fruit from a tree. That's what they're saying. So
you can't use good fruit from a bad tree.
Exactly.
Yeah.
Exactly.
Okay, I see what you're saying. So maybe
is this a suppression?
This could all be thrown out if they
is this a suppression hearing, or is this just his trial? But they're mentioning
I think this is pre-trial and they're
suppressive motions.
Right, exactly.
So they're just mentioning the suppressive motions.
Yeah. I didn't finish it. We still
okay.
I said, you know what? Let me just go up. I was watching it live though. They had some.
I tapped in and I heard the intro, which is actually important that we all got to keep in mind while watching this. Is these court trials ain't about what you did or not, or if you're guilty or not. It's about what you can prove.
Exactly.
And that's what this suppression is about. If you pull me over illegally on some bullshit that's not legal, and then you find a dead body in the trunk.
So, hold on. So they prove conspiracy with these two niggas?
No, well,
I think that's a separate
what
part.
Did these niggas do an Alford plea? Man, what is the deal, man?
Well, that's the thing. They're trying to suppress evidence. That's what it is.
The Alford plea. The other guy. He didn't admit to guilt, but it was in his best interest to plead guilty based on.
Yeah, of course it is. Okay, so
how he gets separated from all the
how much time is it? No, I'm just asking because
people say that he's not really the guy that's out
how
there
much time does a conspiracy charge carry?
It depends on what the conspiracy is. If it's conspiracy to commit murder or conspiracy to extort, those are two different.
And all that crap.
Yeah, those are two different charges.
And so basically, they could have decided whichever one they could have hit him with at any given time, right? They could have said, "Oh, you're involved with YFN Lucci. You're doing this. You shook down the bowling alley."
Well, they got a lot of evidence and there's a lot of dudes that they run with that's done a lot of shit, shot guys. And
you see what I'm saying, man?
You know what I'm saying?
Now,
it's not like they're just pulling these guys up just randomly. You know what I'm saying? Like, they're just hanging with dudes that's doing heinous shit. One of the dude, he was reading it all. He shot 3 motherfuckers on 3 different occasions. You know what I'm saying? So, yeah, man. I mean, if you're around dudes that's doing that and they're claiming your gang, that's how this works. There's only one way to get, you got to kill the head. So they're thinking like, okay, well, you're the leader to this shit. So you need to be responsible for all this shit.
They lumped them all in. That's why I was like that other guy who just got out or whatever. Gunna. That's why I was like, how? That's why people
Well, he
wondering
could have
like how he get out.
testified though. He could have testified.
Right. That's the
We
big
see
question.
plenty of people testify and get out. You know, I think they did say he did tell.
Of course. Yeah. Look though. Here's my whole thing. Of course a nigga like me is gonna say that. Like, that's what we're here for. To have a different perspective. Of course, Jermaine Miller. Oh, he told. On who? Like, you see what I'm saying? Like I said, I'm the type of nigga, I'll keep it real, bro. If I just think so, oh yeah, he told.
This boy's vicious though. Let's get in here. This boy's kind of vicious. I want you guys to hear this attorney. He's a good one.
Okay, so this is Gunna's attorney.
This is on my cross-examination of the lead officer.
Nah, Gunna's out of there. This ain't Gunna. It's not today.
Okay, so this is just a person telling us what's going on.
Specifically.
Okay.
Starting at page.
Okay.
Line 5.
Yeah, no, they got Young Thug back in court.
Line 3.
Following.
The answer is yes, sir. I do believe there was an arrest warrant. I interrupted. I didn't mean to interrupt, but I interrupted. I said I didn't mean to cut you off. The answer continues. That is what the warrant was for. Yes, sir. Then my question is, and that warrant was from a long time before. If you know, and if you don't know, we can get the information through someone else. Answer, I don't know the exact actual. I then asked, were you aware the warrant or the case was eventually dismissed? Answer, I'm not certain, sir. My question, so law enforcement officers do not have a search warrant, though at that time, this is simply an arrest warrant. Answer, correct. On page 33, which is what the state trying to hijack, to use your word, Your Honor, this motions transcript and wrongly mislead the parties on what it says. The trial court, Honorable Judge Newkirk, on line 14 states, all right, no other evidence, brief argument. The Honorable Mr. Bailey, then District Attorney in Fulton County, said, Your Honor, the defendant has filed this motion through his attorney, Mr. Steele, challenging while seeking to suppress evidence in this case that was collected from Mr. Williams' home at the time. The basis of this motion is, and the Honorable Court interrupts, the only thing he's challenging is marijuana, which is what the state seeks. Mr. Bailey says on line 23, right. The basis of the motion, thank you, Judge, the basis of this motion is essentially that in the motion filed by the defense, that law enforcement officers did not have the right to enter the home, did not have the right to enter the home to effect the warrant. Going down to line 3, it's on page 34, continuing. Mr. Bailey, the district attorney, on page.
Can I interrupt you a second?
Yeah, of course.
IT is about to create a new secure Zoom link, but it's only for the attorneys. You're not to share the link. You understand me? Good? All right, thanks. Okay. I'm sorry, continue.
That's okay.
I apologize.
On page 3, 34, Your Honor, of Court's Exhibit 2, line 3. This is Mr. Bailey, the district attorney at that time, or senior assistant district attorney. On page 3 of the motion, it states, Mr. Williams was arrested on a DeKalb County warrant. However, law enforcement officers unlawfully entered and searched Mr. Williams' home, even though they were supposedly armed with an arrest warrant, and there was no need to search or even enter Mr. Williams' home in an effort to serve this alleged arrest warrant, as there was no lawful reason to force entry in Mr. Williams' home. Then there are 2 parts here. And that's the long and short of it. Did they, meaning police, have the right to effect the arrest warrant? And what did they see once they got inside that would rise to probable cause? Then skipping, Your Honor, to line 21, same page 34. This is Mr. Bailey again. Normally, officers can't just walk into folks' homes. That is well established, but there is a carve out for affecting. Officers have reasonable belief the individuals inside. So it is not this way the state is saying that it's only somehow marijuana. I challenge the entry into Mr. Williams' home. When law enforcement went at home, they allegedly found marijuana, guns, other contraband, And that's when eventually the seizure of all of Mr. Williams' electronic devices that I've challenged, that should have been returned, I've challenged, cannot be used in this case. On page 35, the district attorney said, it's at the end of line 1, Your Honor, or it's the middle.
So if that's basically, those are huge pieces of evidence that they're talking about. You know what I'm saying? The laptops, you know, all of that. I mean, you could imagine those cell phones and different stuff. And what the state is trying to do is use all that evidence. But some of this stuff was from, you know, cases way back. And, you know, if the evidence was suppressed, they're arguing that they were supposed to give some of those devices and stuff back, but they're actually using stuff. But I understand if we're talking RICO now, you know, that's different. But if, you know, it's real dicey, and that's why the judges go to school and they get paid the big bucks to sort this shit out. But it's interesting just the things that he's bringing to the table, and it'll be interesting to see what they come back with. I hope they give us all that.
Line 1. An arrest warrant found on probable cause implicitly carries with it the limited authority to enter a dwelling in which a suspect lives when there is reason to believe he is within. The state is saying the entry into Mr. Williams' home was unlawful. He has his constitutional rights violated. He's a victim. The court should say respectfully, no way, this would litigate it. On page 36, the district attorney continues. It's on line 10, Your Honor, and the parties. Now, were the facts that they knocked and he came to the door and they, meaning the police, Your Honor, detained him, meaning Mr. Williams, then Mr. Steele would be completely correct and they could not enter the home. They affected the arrest warrant. Then skipping to line 19, Your Honor, page 36. So they have all clear lawful authority, talking about the police, to go in to affect the arrest warrant. And then we get to the second point. And it is in the same Wall case. Wall is W-A-L-L. It states on the last page, once inside the apartment, the law enforcement officers had the authority to seize marijuana that was in plain view. I challenge that law enforcement had no right to go into Mr. Williams' abode. And then the prosecutor.
Right. Because some warrants are just for the person, you know, and they'll do that. They'll walk up in your shit and you know, and it'll be a warrant. They probably come to your house and surround your house, but that does not always mean that the warrant is to search everything. It could be to search his part of the house, the bedroom, different things. And if he comes out willingly, a lot of times the search warrant is just for the person. So you got to look into that, you know, because police officers, they make mistakes too, and they be on bullshit too. You know what I'm saying? So I've seen like cases overturned by just technicalities. You know, that's what the lawyers are for. They look at it. 2 or 3 different lawyers look at the whole thing and they try to find loopholes in the case. That's their job.
On page 36, line 25 concludes, that is exactly what we have in this case. Once law enforcement is inside, they see marijuana on the coffee table in the master bedroom suite, and additionally marijuana on the nightstand in the master bedroom, and Detective Gaither further testified there were guns located in the living room. So that is, I challenged, I had a hearing, we won the hearing, it was a final judgment, not appeal. I am not respectfully required to do it again so the state can bring their A game, lose, and then bring their A+ game.
Right. You see that? You see his argument?
Yeah.
I got a cold argument, you know.
Yeah.
He's not required to let them, because they have all the resources. Remember, they got unlimited resources. You know, they can hire witnesses from all over the world or all over, you know, wherever to come in. Expert witnesses, you know, they can do all of that. And they lose So it was supposed to be suppressed, but this is some of the stuff that they're trying to use in this case. Like I said, I don't know the impact of said items or whatever they're arguing right in this particular, because I haven't been following it. I'm gonna be honest, I haven't really been following the whole case, but it's it's just some courtroom etiquette and lingo that goes on in the courtroom, man. You know what I'm saying?
Well, shit, what I will say is that now I understand how come them niggas wasn't getting bond. It never made sense at all to me until today, because you guys was doing fuck shit anyway. Right. So let's keep him up in here to give a certain vision of this, right? Because I don't care what nobody say. When you high profile, you get tried in the public first. Right. The first thing is to get a certain type of perception and view and whatever, be it if
consensus.
It's an article.
Yeah.
Right.
Which is against your constitutional right.
Which is, yeah. And you know what? Is that not the argument, right? You had see, I didn't know that you guys had an arrest warrant, but you did a search and seizure. Like now, like you said, Dr. Hood, well, this is RICO. Hey, man, like you said, if you got a good ass lawyer don't care about none of that. That's for.
But he could be blowing steam. We got to see how this argument boils down. You know what I'm saying?
So you think that the lawyer would go up in there and say they didn't have an arrest warrant when they didn't have a search warrant when they really did?
Well, he's arguing.
He would say that?
You said, oh wait, go run that back.
I said, do you think the defense attorney would say the police didn't have a search and seizure warrant when they really did?
Well, nah, he's but still, he's got to see, because sometimes a judge can rule and say, well, it's cool. You know what I'm saying? Or I'm not gonna give you that one. Or maybe you won, because it's kind of, I noticed, man, this with the courtrooms, it's a game.
It sure is
game up in there, bro. So
yeah,
and as sad as it is, and the way it works, it's like weird. You really can't tell. Like, he's making a hell of an argument, you know what I'm saying? But he could just be swinging at the air, because I don't know how the judge is perceiving this shit. You see what I'm saying? Like, yeah, if I was the judge, yeah, he'd probably win this argument, right? But I'm not him. And then
and these judges be the biggest crooks in the system. If y'all really think about it, that shit trickles down to the police, but them judges be the real crooks. I don't know if y'all heard that case in Tacoma where they found the sheriff not guilty.
Was crazy.
Oh, he's not guilty?
Yeah, they
bro,
found him not guilty yesterday.
Troyer?
I expected you to do a show on that today.
Man, we gotta do his fuck ass.
Yeah. They found him not guilty, but what I'm saying is,
guilty.
Everybody expected this dude, and I did too. I seen the video months ago. But you know what I'm saying? These sheriffs, these judges, these guys are elected officials. And judges and sheriffs, they sit in a position for 30 years.
Yeah.
You know what I'm saying? These judges sit on these benches for 30, 40 years, man. And
that's scary, man.
They're the biggest crook. You know that what's that jail up there on Pack Highway, Score?
Yeah.
You know Score was actually funded by 3 judges? 3 judges, and 2 of them was serving on the bench when they bought that prison. And nobody pulled up how that was a conflict of interest for judges to be invested into a prison that they're sentencing people to.
Jaywalking, you're going to Score, buddy.
Yep.
FTA.
Whatchamacallit, Steve put me on that. But yeah, man, so these.
No, go ahead. Let me see. I was on this lead attorney too. He be over there. They attorneys, so they.
Yo,
you get that. You gotta
have a damn good
my
lawyer.
man, Game of Tyrone's out there, huge supporter of the lead. and he's also over there on your channel. Is that
Oh
right?
yeah, huge supporter on my side too. It's gonna be great to meet you, Game of Tyrone.
Yeah, so we are just waiting for the judge to come back in. Guys, also shout out again to the mental fit chick. You know, she talks about getting her.
Let me see.
All right, tell us what's going on in that case. What's going on in the Meg Thee Stallion, Tory Lanez case?
So we got back, and then immediately the defense attorney was saying there was a discovery violation. He was mad and telling the judge, look, they didn't submit these documents that they're trying to put in now. They're trying to introduce stuff that he didn't see before. So he was talking about that, and he's like, can I... Sorry, I thought you dropped me down.
No, you're good.
He said, can I look at these after, or can we come back to this after? Because they did not show me this. So they were arguing over that. And then after that, he was pretty much like, deal with it between yourselves, show him what you need to show him before, and we'll come back to it. And then they introduced a different witness out of order. They introduced Dr. Laruno. He's an orthopedic surgeon from Cedars-Sinai. And he basically talked about cleaning her wound on her feet, showed x-rays of the feet.
Shout out to the feet. I hear you. Well, listen, thank you so much, Trey Guy. Your connection is kind of breaking up a little bit, and you got some sound issues.
Yeah,
but okay, your phone's down. We'll try to bring you back pretty soon. All right. Thank you so much. All right. Shout out to him. We are still waiting, guys, on the judge to come back. He should be back momentarily. Do want to show you guys, you know, what we are talking about for the people that missed it.
That was a really good summary. It's so funny because we were just talking about evidence in this case, and it sounds like that was an issue that came up in the Meg Thee Stallion and Tory Lanez case just now. So,
exactly. Let me read you guys a little bit about, you know, the indictment that Young Thug is involved in. Conscientiousness. I mean, let's just take a look at it right quick. Let's shout out to Nasha. What is Nasha? Here's Demise right here. Demise and Walters, attempted murder. Now, guys, this is the indictment that Young Thug is under. All right, this is a real thing. This is a real case. This RICO case is serious. With malice aforethought and intent to kill, did shoot Dexter Montgomery with a firearm. Demise, attempted murder. With malice aforethought and intent to kill, did shoot Cornelius Davis. Demise and Walter, attempted murder. With malice aforethought and intent to kill, did shoot D'Angelo White. Attempted murder. Demise and Walter did, with malice aforethought and intent to kill, did shoot Christian James. Like, Jesus Christ, Demise, Jesus, Walter. Here's Demise again. Possession of a firearm by a convicted felon. Theft by receiving stolen property. Possession of cocaine with intent to distribute. Possession of marijuana with intent to distribute. Sale of cocaine. Demise was in these streets. Demise was... Good luck to the woman that marries Demise. Listen, guys. You know, so this is a real case. This is an absolutely real case. You know, you got sale of cocaine, you got all these weapons violations, you got attempted murders, you have murders. This case is not for play. All right. I know it's crazy because Young Thug and Gunna were wrapped up in it, but this is real gangland shit. All right, it looks like the judge is trying to come back on the bench in a second. Let us jump to it. And let's see where we are with it. But this is a very interesting case, guys. Very, very interesting case. Thank y'all for hitting the like.
All of that shit, I don't know how they're gonna explain all that, you know what I'm saying? Or whatever, you know, but he's trying to They're trying to get their self off of it. That's what it sounds like to me. And they're using these good lawyers to kind of, make it seem like, hey, man, we're just rappers. Because if without the lawyers, that's an uphill battle, with all the shit that is they homies is doing. But if they basically pin it on them like Gunna did, they said he snitched. So I don't know.
You still there, Hood?
Like button if y'all can like this and share it if you want people to know about what's going on with Young Thug. Now, Gunna again has already pleaded guilty. So Gunna has already pleaded guilty. He is a felon now. He pleaded guilty to some of these charges, but he got time served. So he was actually released yesterday. So he's a free man. Now everybody is wondering, number one, did he snitch? And number two, is Young Thug similarly going to be released? Shout out to Jordan Landry for becoming a member. Thank you, thank you, thank you. Shout out to Miracle. And let's talk about this, guys. What does Miracle say? Free Young Thug, please. Now, I just read you the fucking indictment. I read you part of it. It's a 66-page indictment. Multiple counts, 66 pages, I think it was. Y'all heard the stuff that was on there. Y'all heard the stuff that Walter was doing. Y'all heard the stuff that Demise was doing. I didn't even get to the stuff that they charged Young Thug with doing. Let me ask you, do you guys agree with Miracle? Put free if you think they should free Young Thug. Put free. Put prison if you think they should not free him. If you think that he should go to prison, put prison.
Yeah, I don't know what he did to make any type of vote on that, right?
Right. I'm with you. I don't know this young brother's character like that. Know him personally. Just because he got the charges don't mean that he's guilty. That's what, how could you take a poll on that? It's innocent to proven guilty. That's what it's supposed to be, but it seemed like it's more guilty to proven innocent.
Man, facts. Let me see.
Discuss. It is just not even arguable that case matters to this. They had additional reason to go into the home, into the car in Alford. They had the automobile exception. That is my argument when you asked me. I hope I answered your question. And I think I'll answer any other question, but I hope I answered your question.
You did, sir. You did. Ms. Rosenwald?
Your Honor,
I
know Mr. Steele has an interpretation of the language of the order.
I think that his interpretation is right. I'm just going to tell you that. I look at the way it's capped, it's styled and everything.
You hear the judge, man? And man said, man, that shit is, I think the interpretation is right. So
Yeah,
he really.
No, my fault. Go ahead. My fault.
Nah. Just you don't know how he's hearing it. It
Well, yeah,
sounds
but
clear to me.
You heard him earlier too. The judge is the one who brought up the fact that them cell phones were supposed to be brought back, given back, and not supposed to be used in this case.
Right.
So
and they used
this sounds like
technology wasn't good back then, but now they got some different technology, and they're trying to run the test again on shit that was already cleared and should have been returned.
Mm-hmm.
So they running a sick game.
So they just holding on to his property, trying to just recycle it.
Wow.
They're trying to recycle evidence for let's use it on this case.
Everything. Yeah. Yep. It'll fit somewhere. Let's use it as a puzzle piece,
So this is actually good, man, because see, the judge is the one who determines what evidence gets suppressed moving forward. This could turn into a jury trial, but this judge is going to determine what evidence is allowed in that trial, whether he's presiding over the case or not.
Yeah,
you know what I mean? This could be passed on to another judge, but he's in charge of this suppression hearing.
Yep.
So that's a plus for him if they can get some of that stuff taken out.
Yeah, this guy might go free, man. If Troyer's free, this guy's just gonna be free, man. They ain't really got. I don't really know about the evidence that they actually have on him. The guns in the house, all this, but that could just be one. You see what I'm saying? Like let's say I had a Ring camera on, and the police officer walked up and just walked in my house, and then they saw all this shit right now, and then they lied and said that they knocked. Yeah, I knocked twice, but I got it on camera that they didn't. Right then and there, everything in that house is supposed to get thrown the fuck out.
Yep.
You know what I'm saying?
Illegal search.
So this shit it's dicey, man. It'd be a lot of lying, and if they can catch them in a lie, that's not looking good on the credibility. It's not. It's not supposed to, I should say, because the judge gotta figure it out. But nah, he's shooting her down. Let's see what happens.
Else, and it makes sense with what you're asking me to do is kind of just narrowly kind of look at the marijuana and not anything else has been seized. He challenged everything that was taken at that particular point in time, and it's clear in the transcript that he did in fact assert the fruit of the poisonous tree. I mean,
so Your Honor, if I may, when I looked at this case first and I saw his motion, I was sort of thinking the same way as the court. And then I thought, I'm going to check the case law. And I'm going to check what the actual order says. And when I looked at the order, that's when I started thinking it might be something different. And whether or not we interpret it a certain way, the language itself, the plain language, and I know that the directive from the appellate courts has been to look at the plain language of statutes, to look at the plain language of orders. The language itself says, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana. If the court had intended to suppress the remainder of the items after just stating, so the court says, the court grants defendant's supplemental motion to suppress any and all evidence located from defendant's home. He could have just said that, and that would have been a different ruling. But instead, the judge then said, based on this ruling, the evidence located in defendant Williams' home that is subject to the above referenced accusation number, specifically the just over an ounce of marijuana, is hereby suppressed. If the court wanted to make a ruling on the piece of poisonous tree, it could have, but it's clear from the transcript. And I'm not going to say Mr. Steele didn't argue about that during the hearing, but he didn't ask the court, hey, Judge Newkirk, can you please make a ruling on the fruit of the poisonous tree? There was no ruling on fruit of the poisonous tree. We're not talking about a second bite of the apple here. We're talking about him now challenging a search warrant that was not challenged before. And I think
though, that's the thing about it. I mean, I think it's clear from reading the transcript and the exhibits 1 through 10 that were admitted when we were here on the 17th of November that he challenged everything: the arrest warrant, the search warrant, and he, in fact, he filed a supplemental motion to that extent. So Judge Newkirk granted the marijuana was only the subject matter of what you prosecuted him for at that point in time. You had other things that were seized.
Yeah, they felt
I don't. Now, Your Honor,
I still have an issue of that because you would have still had to return his property to him.
Your Honor, I'm sorry. I have to respectfully disagree with the court. Here, it's not a situation of what Mr. Steele challenged at the previous motion. It's what was ruled upon. There was no ruling upon the.
So if I had $200 and this situation happened, you wouldn't have to return the $200 to me if I won my motion to suppress?
Your Honor, if I had a search warrant that was valid, currently being executed for your $200, and it was for a separate investigation, a separate case, my position is that no, I would not have to return it until that separate investigation, that separate case was done, because I had a valid search. And obviously,
Do you have some case law that interprets 17-5-30 in terms specifically the possession of which is not otherwise unlawful? Because that to me says.
Man, this is dicey, man.
She is acting like she got balls.
She's been there, but he's chewing.
Is that a brother? Is that a brother in that? That's a judge.
Yes, sir.
Brother.
Yes,
Yeah,
sir.
Yes,
it is.
He debunking a lot of what she trying to bring, but
he's not trying to hear it.
Right.
He's not having it. Because she started out, well, he didn't challenge it, all this, and he said, wait a minute. Yes, he did challenge all of that. He challenged everything.
If I had a valid search warrant, I don't have to give you $200 back or whatever. Man.
But she hit him with the, she wouldn't do the. Let's listen because it was getting
good. He should go down.
That would be any contraband, weapons, or things that you're not required to, not allowed to otherwise possess. But it doesn't distinguish on investigations or you holding on to evidence that otherwise should be returned.
Your Honor, I don't have a ruling a case at this time. I'm happy to provide that in a supplemental filing. But again, my understanding of the law is and has been that where there is, if a search warrant is currently being executed on a cell phone, for instance, the police are allowed to retain that property as part of an ongoing investigation.
But he won the motion to suppress.
On the marijuana case, Your Honor, not.
But you took more than the marijuana. He wouldn't get the marijuana back anyways. He wouldn't get any cocaine that came back anyways. He wouldn't get a gun back if he's a convicted felon. But anything else that was proper, that was taken from that particular, house subject to the warrant, it's not otherwise illegal, is returned. The 17-5-30 says shall return and not be subject to further prosecution, because that's the whole thing about it is you don't get another bite at the apple based on this particular evidence. You can go ahead and do some, a separate investigation or whatever, but this evidence is supposed to be returned to the defendant.
Your Honor, our position remains that because there was a separate ongoing investigation for which a valid search warrant was in effect, and there was no rules to fruits the poisonous tree, there was absolutely no reason to return that cell phone. I'm happy to provide the court with an additional brief, but that is our position at this time.
Okay. All right. I'm going to take 5 minutes, okay?
Thank you, Your Honor.
Okay. All right. We're going to be in recess for about 5 minutes.
That judge sound like he getting
He's giving her 5 minutes. Like, look, I'm gonna give you 5 minutes to think about this foolishness you trying to pull up here. I'm gonna give you 5 minutes to get this man his shit back.
Right.
That's basically what he said.
It's evident he wasn't gonna get the weed back and the gun back. But.
Right. It's like, man, you should have gave this man his phone back alone. His cell phone.
It states one for purpose of the motion.
And Your Honor, then we'd also do to admit a certified copy of the search warrant to enter the defendant's home. This was actually attached as an exhibit to the previous transcript. Again, we'd just like to admit this for the purposes of perfecting the record. It's a certified copy.
Okay.
I'll object. It's attached as Court's Exhibit Number 2, pages 57 and 58.
All right.
No, it's already, the court admitted that as an exhibit earlier today.
Oh, the transcript was admitted, Your Honor, but we'd like to admit the certified.
Okay. All right. Certified copy. States 2 for purpose of the motion?
Yes.
Okay. All right.
As Mr. Steele stated, the other one was D10.
Yeah, I've got, that's admitted already.
Is that
So,
certified, Mr. Steele? No.
but it was admitted on the in the hearing on the 17th of November.
May we also tender this as a certified copy of that search warrant, though? As states 3.
All right. Any objection? Or same objection, sir?
Yes, sir.
Okay. All right. States 3 is admitted for purposes of the motion.
Thank you, Your Honor.
No, I'm good. I'm good. Anything else? Anything else in terms of the states and states 1, 2, or 3 for purpose of motion?
Well, Your Honor, we would ask to have a hearing to have the opportunity to show that lawful entry to the house and the search warrant for the phone, but we weren't sure if the court was going to allow us to do that. But if we are, we're ready to do that. We'd like to do that.
I'm not inclined to have a hearing on this, okay? Because, and here's why. The Judge Newkirk's ruling fairly contains some principles of criminal procedure. And even though you've admitted these particular items for purposes of the record, which would supplant Baez and some, and would make the issue of your, that's one argument you could make in terms of the sufficiency of the arrest warrant and the search warrant. The issue still becomes is that that issue was decided by Judge Newkirk earlier, and you all from the state have not given me any. You're still not getting over 17-5-30. There still would be no reason for you not to have returned this property. There's nothing in law that would indicate to the court that you had the right to, to maintain and continue to investigate on those particular items that were taken. But so that's why I don't need to have a hearing necessarily on it, on that particular issue. So with that,
Your Honor, would the court permit the state, we would like to proffer what the evidence would show, where we permitted to introduce the witnesses that we have, as the court.
I'm okay with that. I'm okay with you all. Well, I mean, the warrants would supplant the certified copies of the warrants that you have at this point in time would supplant Mr. Steele's argument. But the problem that you're going to have is that 17-5-30 would require you to still return that particular property. There's no case law which indicates that particular issue, and the statute is pretty clear. It says, motion, if the motion is granted, because Judge Newkirk granted that motion, and it shall not be admissible against evidence of movement in any trial. So basically, you're getting a second bite at the apple. And that particular circumstance, that's why the legislature makes some very specific issues about 17-5-25, which is execution warrants, 17-5-30, which is motions to suppress, and then 17 17-5-54, which is different. That's trial disposition of property. So in that respect, that's why in this particular circumstance, you all still, now, if you've got another argument as to why you didn't, other than why you didn't return his property, but you would have still needed to return it. I mean, you didn't go forward with that prosecution. If you've got some other case law you want me to look at, but it's pretty clear. The reason that the legislature did this enact the statute is because they didn't want the state.
Yeah, their audio be trash.
Hey, my nigga.
So his lawyer is the one that uncovered that pretty much exposed that loophole to get the judge to even be looking at it. You know what I'm saying?
He wouldn't even look at it. They won't even look at it. They just gloss right over it.
I'm gonna keep it real, man. It kind of seems like the judge.
Yeah, and Mr. Steele's argument is.
Hold up.
And just
go ahead, Chef.
It kind of seems like the judge has a particular issue with this particular thing. It seems like he's extremely well versed on it, and it seems like it's a common thing that often happens, but usually, like Dark Kent was saying, you don't really have a lawyer to really present that, right? As a judge, it's not your job to do that stuff. As a judge, you have the freedom to, but usually judges let that work itself out and whoever presents the best argument. But it just seems like a lot of shit like this that came across his desk, and he's just like, nah, we finally got somebody who says something. Nope, you still got to do it. He keeps like reiterating, you still have to do it. Yep, I understand that, but you would still have to give the property back for X, Y, and Z. So this is like interesting. This has to be a state case, bro.
Obviously, they must have how they how they gather up their evidence. He ain't feeling it, and then they didn't get the man property back. So he pretty much calling them out on that. You know what I'm saying? Y'all didn't do the formalities or the proper procedure or whatever. You supposed to get this man his property back, and y'all held on to it so you can add on some more shit or investigate other things or whatever to use it as your advantage. And he's like, nah.
Yeah, they're using it to dig. They're using it to dig because they're trying to get every little thing.
That's clear what they're doing with their
digging
devices.
They're
absolutely
digging for evidence.
Yep.
And that usually happens when you don't have enough evidence.
Yep.
Then you start to digging for shit. You know what I'm saying? So
let me ask y'all a question. Did your boy Gunna, did he plead too early? Because it seemed like your man, I'm just my opinion, sound like your man might get pulled through with the loophole his lawyer exposed, and hey, he might get free. Because all this was some bullshit. How they let him out.
Gunna. So you say just taking his well, no,
right,
see, this is just this
so early.
See, I don't know.
I mean,
man.
should have waited it out versus just saying, yeah, I'm gonna just take the plea deal or whatever. And you know, I don't know, maybe he probably just like, I can't do this, the jail thing or whatever. Maybe it's just becoming too much.
Yeah, I mean, the
and he
nigga, man, from what I understand, he agreed to 5 years, right?
Nah, I thought he got off on time served.
He got out. He out with time served. So
that's what I heard.
Just pleaded guilty. Right, he pleaded guilty, but he's out. So
yeah,
I don't know. Did he get probation or something? Or
yeah, I think he got some type of probation, and you know,
and that's gonna look suspect in the hood, right? If you
man,
supposed to be
this outcome, bro,
organization that's supposed to be known as a street.
We need you niggas to get.
But if he's not doing none of that,
we need to get.
One
of you niggas need to get your attorneys over
you
here.
know, for yourself though,
that's what we need.
You guilty by association, always.
I mean, not in the court of law. Not when I go to court. I'm not.
No, I'm talking about on
my
the
lawyer his job is to get me off.
Right, I'm talking about on the street though. You know, your mans may not look at it like that. Why you out early? And you know,
yeah, that's when you gotta. That's what we talk about. The hood ain't shit, though. You know, the hood's
right.
they're gonna think this, and it ain't gonna be in your best interest. I bet you that. Whatever they think, it's not gonna be in your best interest.
Yeah, right.
So to prove them niggas that you didn't tell, like if dude told, he told. But if he didn't tell, like he has nothing to prove. They have to prove that he told. Like, where's the paperwork?
Right.
Where's
but
you know,
dudes don't listen to that, man. Even if you do got something valid to say that you did. You know what I'm saying? Niggas don't just think anyway. But and mind you, for the record, I don't wish nothing bad on neither one of these brothers because I don't know them personally. You know what I'm saying? So,
yeah, that's gonna be some more developments coming out. Like I said, I'm just getting into it. It seems real interesting. I seen a couple other court dates and stuff. It wasn't too much going on. But now they're getting down into it. So whoever does end up going to trial or whatever.
But it seems like since by what this judge has been saying so far, it's going to weaken the prosecutor's case even more. So their case is going to get weakened even more.
For that, but they probably got them on some other shit though. For that, yes. Like I see them losing this argument. Now, if that's the hatchet in his back, I don't know because I haven't been following it. That's all I'm saying.
Right.
Now, if this is all we're looking at, I say yeah, he has a good chance. But if there's other shit, and this is just one little ass thing out of 5 things that this guy is facing, I don't know how you're gonna explain the other shit.
But that one little thing that they were trying to use would help open Pandora box to all the other charges that they got on them. So I'm saying if this gets thrown out or it gets admissible or what have you, then that's going to definitely weaken all the other charges that you probably got on them, unless you got some concrete.
But if they got some fucking like I said, I don't know exactly what I don't know everything because let's say let's say this little stop and them coming to the house and shouldn't have went in the house to see all the guns and all the other stuff. Let's say that gets thrown out. You know what I'm saying? But let's say that he got 17 phone calls with Demises and shit. He's contacted, he's texting these guys, telling these guys shit what to do. And, because that's what I heard was going on. You know what I'm saying? And
I'm just saying, they came in there, guns loaded, but if the judge, based on what he's saying, is gonna, say this is admissible or you can't use this, it's gonna at least put a hole to where, okay, now he may have a chance even more, because now it's gonna weaken the prosecutor's case to, with all the other stuff that they build up, and it was built up off of that one little thing that this judge,
if that's the case,
that's
what I'm saying. Like we could hypothetically say that, it's just
that's true.
It blows the whole fuse and everybody goes free. You know what I'm saying? We could hypothetically, but just me, you're absolutely right. But just me personally, I don't know if this is it. Like this is it. Yeah, he's got a good chance. But if this is not it, if that's just one toenail off of the big ass fucking, what I'm saying?
What if they built their case just off of that one little thing? And
hypothetically,
the judge is going to discredit. Hypothetically,
right? Yeah,
right.
You'd be
if
right.
The judge is going to discredit that. That's going to.
But if it's not, because they have to go through everything. They let's say you're going down for 3 things, right? They had to address all 3 of them, basically. So if this is just a situation like you got 2 or 3 gun charges, you got this, you got that. And this, let's say this one with the house is one of the gun charges, and then you got a drug charge with the car. So let's say that both of those were illegal. Boom. But you still got 2 more that they could still prove, and it's easy, drop in a bucket type of shit, then you still forced to, maybe take a deal. Maybe the prosecution will cut you a 5-year deal. Maybe they'll do the time served just to get you those felonies like Gunner. Like, okay, I'll let you go, but you got to pay this fine. You got to get probation, and you get the felonies. That might be 2. And how the felonies work, you know, you get the more felonies you get per crime, you get more time.
This Gunna guy, though, you got released. I don't even think has it been a year since? No, they got snatched up this year, so it haven't even been a full year.
But he probably didn't do nothing though. That's what I'm saying. He's just an artist. So if you left your city or whatever, and you go, or even if you live there and you just rapping with these guys, like you're not gonna stay away from them. Like they're millionaires. They're getting money, shows 40,000-50,000 a show. You're living your dream. You're not really thinking that the fucking feds is just gonna come through with the bullshit. You know what I'm saying?
Right. But if it was all funded though with illegal money, your rap career, like for instance, like with Irv Gotti or whatever, even though that I thought that was just some totally bullshit anyway, but you know, it didn't affect the artists per se, like the Ja Rule and Ashanti and Lloyd and all of them, the artists that they had, because the record label was under investigation. The head honcho guys, Irv Gotti, his brother, you know what I'm saying? So it I don't know. So the artists who were under that record label, I don't think they were investigated or got any charges pending against them. It was just the guys who is in charge of the damn record label, which was Irv Gotti and his brother. I'm assuming. So it didn't affect the artist. So the artist didn't get lumped up in their case, in their Fed case. But I see what you're saying though. With the Gunna cat, if he's just an artist, you know what I'm saying, he don't know how his career is getting funded through this record label. He's just making music. But this is interesting though.
If that's what he was doing, he never, like I said, I don't know all the evidence, so. I mean, they probably got Gunner on tape doing some shit. I don't know. I'm just, because you gotta have the evidence. That's one thing. And then the RICO thing, they just try to smash you up. I think it's bullshit though. You said what?
I thought like when they get you, if they get you as a crew or cartel or organized crime or whatever, however they label you, you all are going to go to trial for the charges. It doesn't. How does it get broken down to? Okay, you're all individually charged with something, and now you're going to have all individual lawyers.
Ray Midnight.
That how it go? Or
you say what?
I was saying, like, when you, for his crew, YSL, right?
Right.
They all are getting charged with whatever the charges that the feds came with. So when you are trying to fight the case, you all have to get your individual lawyers, or.
Oh yeah.
Like that's how that worked. And
yeah, hell yeah. Yeah, they're not. They got that plus the smallest motherfuckers probably getting the racketeering. Just organized crime. Even if they don't have him doing shit, they're gonna hit him with that. But the other guys are getting that plus the drug charges, plus the gun charges, plus all the other shit. So they're not all gonna get the same amount of time. There's a lot of dudes. And they want these guys to go free. That's just what I see. I don't see nothing productive having the $1 million artists locked up when it's a lot of those dudes, and that they're gonna be the fall guy. So if you're in the game,
dudes,
you gotta know that
who are actually hands on,
exactly
with the business in the streets. So
Like the guys that he was reading off the thing, dude shot him, all this gun charges,
wow.
you know. He's like, yeah, he said he feels sorry for whoever marries him, you know, because, you know, dude's wild. So he's going to get probably the most time out of all of them. But you all connected. You calling him, you're talking. Once they start tapping the phones, you know, you're talking to him, you're meeting up with him, you know, like, what are you doing with him? You know,
somebody
so that's what Gunna
light
is around and driving cars and going to, you know, got the key to this and you with them. They're doing this. It's not like you didn't know. You probably didn't have any say so, which is understandable, but you knew, you know, what type of crew these guys are, you know.
Or you may have heard some interesting
nah, man, you know, man. You know. You know. You know, man.
Man.
You know what them dudes is up to. Midnight, what up?
Yo,
what up, panel?
Yeah,
I just stepped in a little late, but I also kind of have a little sense of what's going on, but I'm still a little bit like how you guys are about it. But I'll say this about the Gunna shit, man. You know, there's again 50-50. There's the side of the whack 100s and I kind of agree with Boosie in there, man. When you sit up here and say, like, if you my homie, you don't, you know, they looking for you to say that we're a gang and we're an organization, you know. Gunna had to go on court and say that he got caught on video. Somebody filmed it in the court course, saying that they're a gang and they're an organization. You know, even if he ain't had nothing to do with it and all that, of course, you know, he was part of the advisory board. Trust me, he was like still something in command.
Wait.
Yeah. No, I did see that. I did see that.
He said they were a gang.
Yeah, he said that in court. It's circulating. This is viral. This is like
ain't gonna be. That's not gonna be a good look.
Yeah, it's not a good look for Gunna right now. He's free, definitely. He's free right now. But you got Boosie and Gilly the Kid. That's considered street cats. That's in the rap game. Boosie really considerably.
What they say about him though?
Boosie is, from what he's seeing, from what Gunna did, he's calling him a rat, bro. And you know, Boosie just went down. You know, he's been down. You know, he's been in it. He was down for. You know, he was out there. He's one of them cats that's been out there and did it. You know,
did his time.
You don't
and
go
everything.
into the courts of law confirming that you were.
And now no Rico case, like Whack 100 said on a Rico case.
That's probably what they needed him to do. They probably needed him to say that it's a gang.
Somebody's going down. Doug ain't
let him go.
So that's why I was saying he can't be acting like he wasn't. I'm just an artist. Nigga, you went in there and said you acknowledged that this was a gang.
Yeah, because they got too much information.
Well, no, that's still that's not. So you're talking about the hood. The hood's not gonna lock him up. All right.
No. Well, yeah. I'm talking about.
So he very well could have been just acting like he's the artist, and yeah, he does have knowledge that that is a rap group and a gang. Yes. How hard is that to know? Like, how many times you got to kick it with me? And if I got a studio and you know that we rap and these is gang members around.
Okay, well, listen, for instance, here's
I wouldn't confirm that even in the courts, man. I wouldn't confirm nothing like that.
Well, then you wouldn't get the deal and you're not going home. That's how that works. He would have still been locked up.
This is how we know Gunna is involved. This is, first of all, he was booked for like almost 15 months. You know, they was almost booked the whole year. He put out an album. They put out a compilation album and they booked them. They called them out before they could go on tour, all that, make any money. They did in a timely manner. First of all, we know this is how we know Gunna's involved. We could look at the past and know. We could look at the BMF situation, like you guys are using the artist as an example. Jeezy was an artist, a big artist.
Right.
You know, for BMF. That they use as, we could consider as a front for what we all know what they were doing, correct? You know what I'm saying? Gunna is that same caliber, but when BMF went down, Jeezy, they didn't lock Jeezy up. You get what I'm saying? But we know that Jeezy knew what was going on, and we know that he probably, you get what I'm saying? You know, hypothetically speaking, allegedly.
But if he would have got swooped up, the fact that you went in the courts and acknowledged, you know what I'm saying, that you were part of a gang, even though you're an artist, you know what I'm saying? And I'm not, you know, talking about what the hood, what type of judge and jury they gonna be, but the fact that we in here fighting this case and you are
say
going
that
in the courts,
yeah.
right? And you say that you ain't helping me, you ain't helping my case.
That's what
you ain't
Boosie's
helping the
saying.
others. You're not helping the cases of the other people that's still locked down either.
Right. That's
you
what
could have
Boosie.
just stuck with we're artists. This was a record label.
Yeah,
We're
I'm an
artists.
artist. I ain't got nothing to do with that.
Right. I'm not aware of anything outside of that. All I know
Right.
is we do art of music. That's it.
Right.
You
That's
don't
what I was
say,
drunk here too.
we're a gang and we do art. You don't have to. You ain't got to help them with their case. You don't have to add to it. Just I'm an artist. This is a record label.
Right. That's what Boosie and them is saying. That and Boosie, for that matter, they label him as a snitch.
So now you're gonna make it. Now you're gonna make it even harder for the rest of those guys who got to fight the case, regardless if they're guilty or not. Now you're gonna make it even harder because you went on record and said that you acknowledged that this was a gang, this organization or whatever, versus just sticking to, you know, hey, this is a record label. I'm an artist.
I don't got nothing to do with none of this.
I don't know anything outside of that.
Well, sir, we got you on tape. Hey, man, I didn't even know. I was just riding along.
Tape what? Tape recording? Yeah, I got plenty of CDs.
No.
No,
Look,
I'm saying that just I'm saying that as
oh,
a
okay,
person,
yeah.
You know, just figuratively speaking. Yeah, what tape? You got me on tape? What, recording music?
Right.
I'm
like,
I'm
we got you on tape. We got you on tape being at the scene. Like I didn't even know what was going on.
What, a video movie shoot? You sure it was a scene of something? We was doing
don't play with us
too.
Don't play with us, sir.
Let me hear this judge.
Okay, hear me out. You didn't have a valid arrest warrant to begin with. Now you got one, but you didn't have one when you had one in front of Judge Newkirk. You sought a search warrant, so you weren't in the right place and space to begin with, because you went in the house, somebody saw some marijuana, or somebody saw whatever it is, and they, in D10, they got they drew an affidavit, and they said, okay, we want to search the house. Well, you got to be in the right place and space to begin with to have the authority to search the house to begin with. Mr. Steele in his motions asked for suppression of anything that was taken in the house. So marijuana and anything else that was the basis of that. So that's fruit of the poisonous tree. He's argued that all throughout his motion. He's argued that. And so Judge Newkirk, by implication, had to consider it as part of his ruling. So you asking me to kind of, okay, well, the marijuana's over here, that's fine, but he didn't suppress the other stuff. We can still use it. That's not the way I interpret this particular scenario and interpret the law related to search and seizure of this particular item.
Your Honor, thank you. And respectfully, the issue of whether or not the state had a valid arrest warrant is actually proven with respect to, did we have one with the certified document that the court has that the state has tendered as evidence. So it's not a matter that the state did not have lawful authority to enter into the home.
But you didn't have it at the time that Mr. Steele.
Did they let the black woman get up there and reinforce the argument?
We had the search warrant. That search warrant, that certified document that is in evidence, Your Honor, has a date on it. It was signed and filed well before Mr. Steele made that motion, and it was a part of the record of the clerk of court.
But you all didn't.
It was sworn out again.
The challenge is you all didn't take that up on appeal or anything. It was ruled upon by Judge Newkirk.
Your Honor.
So at this point in time, is it fair to Mr. Williams for you to have another bite at the apple? I mean, at this point, because you're asking me to go ahead and let you use this particular evidence that arguably another one of my judicial colleagues has said, hey, despite the fact that we disagree about how the motion has been styled, clearly it would be subject to being suppressed.
And Your Honor,
and even if I agree with you, okay, let's say you corrected all that. 17-530 is still fatal to you. You still would have needed to return the property, and you haven't given me any legal justification for you to keep that property and continue to then investigate that property or search that property. Unlike trial evidence that clear you could have done that. 17-530 is distinguishable because it's like the legislature seemed to indicate, well, we don't want the state to go ahead and continue to keep investigating an individual based on evidence that a court has suppressed. So that's kind of where I am.
Your Honor, if I may, the distinction is that there was a good faith basis for obtaining the search warrant and for getting the search warrant. A search warrant affidavit for the home itself was sworn out. There was, in fact, an arrest warrant that did exist. It was lawful. The fact that there was not one presented in the 16 SC case is what, yes, caused Judge Newkirk to suppress the evidence as to that case, Your Honor.
Okay, and why didn't you return the other stuff to Mr. Williams? You wouldn't have had to return the contraband. Everybody's clear about that. Contraband or weapons would not have been returnable to Mr. Williams. Why didn't you return the other stuff?
We had actually sought the search warrant, Your Honor, and I think that the court can look at the dates on the search warrant, on the arrest warrants, and see that we had actually already received lawful authority to search. We had already sought and obtained a search warrant for the items. We had already obtained what the state believed was lawful authority.
If Judge Newkirk has already suppressed the marijuana under the same analysis, okay, then why wouldn't the rest of the stuff that you took be suppressible at that point in time and through the poisonous tree?
Your Honor, the ruling by Judge Newkirk came after the state sought permission to search the items. So we had what we believed to be lawful authority to search the items, the search warrants that were obtained, and we have witnesses that will testify.
Assume I believe you, okay? Assume I believe you.
Yes, Your Honor.
All right. Still, Judge Newkirk grants the motion to suppress. The case is over. You can't proceed on the 16 SC case anymore. The evidence that you all took, why didn't you return it?
Because, Your Honor, at that point, we have, from sources, we have probable cause to believe that within items located within Mr. Williams' home, and this is separate and apart from the fact that he possessed marijuana, but at this point, we have information independent of that to believe that within his home, we would find evidence of these other crimes that we were at that point investigating. Prior to Judge Newkirk hearing the motions, prior to Judge Newkirk issuing the order that he issued, even if the court were to see it as more expansive than the state believes that it is, we had probable cause based on information and sources independent of the fact that the defendant had marijuana or firearms or whatever it was that was seen when the officers initially entered the home to execute what was and what is. It doesn't change it. The fact that the arrest warrant that was in existence at the time actually was valid and gave them lawful authority to enter the home does not.
Judge Newkirk ruled that you didn't have that at that point in time, because at the hearing that you had in front of him, or Mr. Bailey represented you all on the 3rd of April, of 2017, that was, you didn't have that particular certified copy of the arrest warrant. And so Mr. Steele, by argument, says, hey, look, I am extending my motion. I'm going to include everything that's in the house because you weren't validly in the correct space and place. Now, had you had that search warrant at that point in time, or not search warrant, but the arrest warrant valid at that point in time, then Judge Newkirk would have probably said, okay, well, then you're fine. But that wasn't that, these particular scenarios have to be ruled upon in terms of what the judge has at that point in time. So if you look at that, even if I accept, which I have, I've admitted, states 1, 2, and 3, you still have to return the man's property. He's asked for it to be returned. He hasn't had it returned pursuant to 17-5-30, because I can't go back and unring the bell in terms of Judge Newkirk's. You're not saying Judge Newkirk's ruling was erroneous, are you?
I'm saying that Judge Newkirk's finding was that we had not presented a certified copy of the arrest warrant, which is not the same as that there was an unlawful search and seizure. It's just that the state had not tendered.
On 3 April 2017, that's exactly what he was doing. Okay, so you're asking me at this point in time to say, hey, Judge, we can put that. On December the 15th of 2022, you've introduced states 1, 2, and 3 certified copies of the arrest warrant, the return of search warrant and inventory, and the affidavit for search warrant. And that's why I'm telling you, assuming that that is now corrected, the problem that you still would have is the return of property under 17-5-30, because you took the marijuana and the other pieces of evidence from Mr. Williams' home. I don't think the law distinguishes between that. So you would have had to return that. You still would have to return the property to him. So because at this point in time, he's entitled, or he would have been entitled, he's asked, and Mr. Steele has already introduced from in the last hearing on the 17th, he's asked me, or he's introduced a letter that he sent to Mr. Bailey saying, hey, I want the evidence back.
Your Honor, but the court did not rule that the state had to return that evidence, number one. There was no ruling as to that. I disagree.
I disagree with you. I disagree. By implication, Judge Newkirk had to have considered the fruit of the poisonous tree. Mr. Steele asked him to do that. And it's a snapshot in time. So on the 3rd of April, 2017, you didn't have what you have now. And so you're asking me to correct something that is arguably, can I do that? I mean, and even if I can, that still runs afoul of 17-5-30. You still would have had to return Mr. Williams' property. And then Mr. Steele asked you for the return of that property. And there's no exception under 17-5-30 pretrial that gives you the ability to keep the property. You have to return the property. The property that, and then you took that particular property, in particular his phone, and then you extricated things out of it, which would be tainted or fruit of the poisonous tree, because you didn't have the right to keep that. You didn't have the right to keep that particular evidence under 17-5-30.
Thank you, Your Honor.
All right. All right, let me finish what I was going to say, okay? For purposes of Mr. Steele, you can prepare an order, okay? Sufficient to recap what the court has indicated during this particular motion. Now, I know that puts us in a position where some stuff that you may have the state was going to admit or utilize. Does that change your position, ladies and sir, about where you are with what would be admissible in this particular prosecution?
Your Honor, there are items that, of course, are affected by the courts suppressing the evidence that was seized back in 2015. There are some items that we believe may have more evidentiary value than others. And so it does affect the evidence that the state intended to introduce in this case.
Well, I was just asking because if you need to sit and talk with Mr. Steele about what you can agree that would be not admissible at this point in time, given my ruling.
Further, Your Honor, Regis, R-E-G-I-S-T-E.
One more time, R-E-G what?
I-S-T-E.
Okay.
Versus the state. And that is 292, Georgia 154. It's a 2012 case that is directly on point with what we have at hand. As an initial matter, telephone billing records are business records owned by the telephone company, not the defendant. As a result, defendants generally lack standing to challenge the release of such records under the Fourth Amendment because they do not have a reasonable expectation of privacy in records belonging to someone else. And that's a pen site of 249 Georgia 462 at 469. Accordingly, the court held that the appellant was not entitled to challenge the release of phone records in this case on Fourth Amendment grounds. Your Honor, the issue of standing has to be addressed before the court begins to even look at any substantive matters in this case. And given that the defendant has no reasonable expectation of privacy in the cell phone records of the Hertz Corporation, he has no grounds, no standing. He has nothing that permits him to come in and argue that the court should somehow find that the state's method of obtaining those documents was somehow improper. Additionally, Your Honor, the documents were turned.
She ain't making a great argument, but I'm not the one hearing it.
Hey, I just wanted to say, man, they was fighting hard for that piece of, for that particular piece of evidence or what have you. They was fighting hard for that, which lead me to believe that they really need that. You know what I'm saying? To help strengthen their case. Because they was, and the judge kept on saying he kept repeating the same thing over and over again. And it's like, okay, what part you don't
guns in the
understand?
house and all that. Yeah, hell yeah. They need that. Because they're trying to string him with the all the organized crime that been going on.
I'm talking about the property stuff. You know what I'm saying? They didn't do their due diligence, or it wasn't. They were supposed to return his property back in the midst of all of this. So they didn't do that, which, like you said, it could be a technicality to weaken it could be to weaken their case. And I'm like, they going so hard over that, because you would have understood it in the beginning when he said that, okay, he could throw this part out. Okay, fine, we're going to move on because we still got other things that our case is strong on. But they was pretty much fighting hard for that, which lead me to believe, in my opinion, that they really needed that.
Or they just fight hard for everything, one of the two.
Yeah.
Over to the state by the Hertz Corporation. If the Hertz Corporation wanted to contest the release of its own documents, the Hertz Corporation and only the Hertz Corporation, and all that they released, I will also make clear, it's not at all anything comparable to information contained in cell site location data that a person has within a cell phone that is keep on their person and that moves around with them. These documents are simply documents that show that the defendant rented from Hertz a particular vehicle at a particular time and returned said vehicle at a particular time. There's no location information data to which the defendant could in any reasonable way have a reasonable expectation of privacy. Additionally, Your Honor, again, the records do not belong to him. He has no standing, no expectation of privacy in them, and he is not properly before the court contesting or moving that the court suppress the release of Hertz's own records to the state. So again, as well, Your Honor, the law on standing requires that the defendant show that he has standing, and his claiming that, just baldly claiming that the information sought somehow references or, as he put it, it touched upon the defendant or information concerning the defendant, still does not give him any standing to argue or ask that the court suppress information lawfully turned over that he has no expectation of privacy in, even if it was unlawfully turned over. He cannot argue that the court should suppress these documents. He does not have standing to move the court to suppress the documents. There is no infraction of any law or code of conduct. There is no incursion on any protected rights held by the defendant. There he is.
Yeah, it looks like from Kessler that he has a reasonable expectation of privacy in a conversation. He doesn't have the reasonable expectation of privacy in records. So is that kind of sum and substance what your argument is, madam?
Yes, that's an initial matter, yes. And I mean, I ask the court rule on his lack of standing before we do anything else related to safety, Judge.
Okay. All right, Mr. Steele, what say you about standing? It looks like that these are the Hertz records, correct?
Yeah, they're included, that's true.
Okay, is that what you were, as an initial matter, I would agree with Ms. Lovely, your client does have to have standing. I would agree. I would also tell you that conversations are different than records. So tell me why you think that he has standing to contest these records.
Okay. Well, and when the Honorable Court started to get into this motion, the court actually asked about Mr. Williams' motion to dismiss the indictment and or a motion to suppress evidence and derivative evidence based upon prosecutorial misconduct and abuse of grand jury powers. That was filed on November 3rd, 2022. I supplemented that, Your Honor, on November 10th, 2022. It's the same title, but I wrote a supplement to Mr. Williams' motion to dismiss the indictment and or a motion to suppress. It also goes hand in hand, if you don't mind ruling at one time, I believe it goes hand in hand with the Mr. Williams' motion to suppress number 3.
Well, I need to deal with the issue of phone records again. That's what you asked me to do.
The Hertz records.
The Hertz records. So let's deal with the Hertz records first. There may be other issues as to the indictment and some other things. But let's deal with that first.
See, it's a lot of issues, you know, besides that. You feel me? That's what I was saying. I wasn't really all the way up to speed, but you know, they talk about the phone records and all, you know, they trying to, of course, he got to suppress as much stuff as he can. There might be 10 different things on the table and going in, you know, that'll be better. And then if you fight these things and, you know, it's looking good in your favor, a lot of times the prosecution will try to throw a deal because maybe they don't want to go to trial and face the outcome, you know, so they might try to throw you a sweeter deal. But in my opinion, I think there's more shit that he's looking at besides that. But I don't know. Maybe it's something he could just plead to. He wasn't one of them. You know, all those other dudes, you know, it's a bunch of other dudes. They get thrown under the bus. That's what the youth need to see for what it is, for face value. You know, there's gonna be some guys that's locked up behind this that was trying to be a follower, and this is what happens. You know,
absolutely.
So I've got to abstain in order to address that particular issue.
So I raised it twofold. I raised the motion to dismiss the indictment of prosecutorial misconduct. Records.
We're trying to get the whole
of
thing.
Another company, although we want to assert standing. Maddox MADDOX versus State says that there is no standing in those records. So I will, under the current case law, I'm not waiving the issue, but I'm telling the court, like I'm obligated to do, of the case law, and Maddox is.
So you would agree the state's proposition is correct?
I would agree that.
But you disagree because you represent Mr. Williams. Am I correctly, summarize that, sir?
Well, it's not like because I represent Mr. I think the law is inaccurate, but the way I understand the law today, we have to follow MADDOX versus State 346 Georgia Appeal 674 2018. It's exactly correct what Ms. Love said, that there's no standing in records of a corporation when you rent a car. But that really wasn't my issue. That's why I supplemented it. And that's why I did the separate motion to dismiss the indictment. And
Judge,
the reason.
If I may,
Motion to dismiss the indictment. Whoa.
I hear him going into the substance of a thing that necessarily relies upon his right to complain about the state's method of obtaining the records from Hertz. So I would ask that.
Let me deal as a preliminary matter, threshold matter. If that's the case, the records, your client would not have standing. I would grant the state's motion as to that, as to the Hertz records.
Understood.
Okay, so is there any other basis that you are asking for at this point in time?
Yes.
Okay, all right, what's that?
Okay. So, and the reason I want to call Mr. Sprinkle, if you allow me to briefly proffer.
Okay, you're going to proffer as to why you need to call Mr. Sprinkle.
Yes, because I think that's where it starts. So what happened is, Your Honor, is Mr. Williams is wrongly targeted by law enforcement for 10 years, since he's 21 years of age. And during those 10-year period, there's a systematic abuse of process by the people who claim that other people break the rules, and that's the District Attorney's Office of Fulton County. And what I'd like to call Mr. Sprinkle and prove to the Honorable Court is as follows.
Wow.
First is what you just heard from. Law enforcement officers and the District Attorney's Office is aware that the Honorable Judge Newkirk found that law enforcement had no right to go into Mr. Williams' home in July 15, 2015, take devices. The prosecution does not restore those devices. You already ruled, I know, Judge Newkirk ruled, but that's part of the issues. What right does the prosecution, the District Attorney's Office, have to keep that property and then to send it to Cell-Bright without a warrant and have it searched? I want the court to consider that. Then I want the court to consider the following. The fact that the district attorney's office did not go back to a judge and say, we have this property, we're supposed to give it back. We are doing another investigation, we want another search warrant. They just go and Cellbright, I would introduce through Mr. Sprinkle, says, as a courtesy of the district attorney's office, we're going to look at this device. I would like the court to have that in its breast when deciding whether there's extreme prosecutorial misconduct. Then what happens is grand jury subpoenas. I'm not moving to suppress anything at this point. I'm not waiving any argument, but I'm not moving to suppress. But this is how the grand jury subpoenas were given out in this case. And it's not only hers, it is every grand subpoena. I've attached them to the motion. And what the grand jury subpoena shows is that from his office, presumably, Mr. Sprinkle is on every one of these. He has a district attorney seal.
Smash the like button, y'all. Smash the like button, y'all. This Dr. Hood, we're getting it going. We're getting it going. Smash the button.
On the subpoena. The law requires the clerk to seal a grand jury subpoena. Mr. Sprinkle sends all of these subpoenas outside the state of Georgia. There's no authority for a...
indicate which subpoenas he is referring to when he says all are, because the only one that I'm aware of that he has referenced is the Hertz subpoena to Florida. But as a matter of fact, I would just let him continue and I will not.
Yeah, you shouldn't have never said anything. Like, what are you talking about? You know?
Yeah, he's proffering some why.
Oh, he is actually. He is.
You talking about Thug's attorney? He shouldn't have said anything about.
Nah, old girl shouldn't have said nothing. She should have just let him finish. She don't know anything about it. Let him explain. But she backed up. But they got audio issues. Hold on. This is crazy.
Here is suffering from the state of Georgia's unlawful abuse of their power.
What's the site again?
Mr. Lample's site is (296) Georgia, 892, Division 2, 770 Southeast 2D, 629. 2015, I had the honor of representing Mr. Lample. On that case, it went to Court of Appeals of Georgia, then the state sought certiorari, and that's how the Supreme Court got that case. He's the mayor of Mara. Mr. Lample's the mayor of Mara. Okay. And that's why I would like to call Mr. Sprinkle, because he's sending out, under the auspices of a grand jury subpoena, with the district attorney seal, without the clerk seal, outside our state. They've taken evidence from Mr. Williams' home, not returning it, searching it, regardless of Judge Newkirk's finding. And then, Your Honor, what I'd like you to consider, and Mr. Sprinkle would be asked, there's a recording in a grand jury, and it happens on June 15, 2018. Mr. Sprinkle and law enforcement officers who are present in this courtroom subpoenaed a woman named Ms. Morton, M-O-R-T-O-N. They brought her before the grand jury in Fulton County. They didn't like that she wasn't talking with them. They put her under oath. And they said, it's Mr. Sprinkle is said on recording right at the beginning. It's at 10 seconds of the recording. He says, because in Georgia, it's not an investigative grand jury unless the court deems a special purpose grand jury. It's not federal court where you could do an investigation. The state of Georgia, you need a proposed bill of indictment already against the person and what the charges are. State of Georgia versus Brian Steele, here are the charges. What Mr. Sprinkle tells the grand jury is, this is not an indictment under consideration. We are just here to hear Ms. Morton testify. That's not valid. So I'd like to ask Mr. Sprinkle what right he had to use the grand jury as a district attorney's investigative tool. Those are my five issues. The search warrant, the search of the devices, which we already ruled. Why did that happen? Why did the subpoenas come without a clerk. Third one is why would the subpoenas go outside of the state of Georgia? The fourth one is why wouldn't you return the property? And the fifth one is why would you bring a human being before a grand jury when you don't have a real bill of indictment and you tell the grand jury that this is not a bill of indictment under consideration? What right does the district attorney have? And that's why I subpoenaed the young man. Okay.
Your Honor, the defendant still has not addressed the issue of standing as any of the.
He's indicted.
No, Your Honor. The conduct that he is complaining of, he has to have been aggrieved. He has to have an expectation as it relates to that conduct.
I think that's what he's asking me to test. I think that's what he's asking me to test, and he's also saying, hey, he's an aggrieved person because he's under indictment for these different charges. So,
and Your Honor, if I may, I don't know why Mr. Steele cited Lample in his brief, because it actually supports the state's position in this case. In Lample, a special purpose grand jury investigated the defendant and subpoenaed that defendant. In this case, it isn't even that the defendant was subpoenaed to testify. He is talking about a person who didn't even yield information that was used against him. He is asserting that actions that he has no right to complain of should be somehow used as a basis for dismissing a lawful indictment against this defendant. So he is, I guess, attempting to leverage the court's ruling previously into something that simply doesn't exist. He does not have a right to complain of the actions he asserts were unlawful or improper. He simply doesn't. And he hasn't addressed his being indicted alone does not give him standing to argue or to complain about the fact that Ms. Morton was taken before a grand jury, or that a subpoena was sent to a corporation or a company or an entity that the defendant has no expectation of privacy in. He simply doesn't get past that initial threshold. And by continuing to fold one argument into the other, he attempts to subvert what the courts
Yeah, they audio. I'm gonna just let it play till it kick back in. You know. You know what it is, y'all. Y'all know what it is.
Supreme Court, they've been indicted, and when the Georgia Supreme Court says, nope, you lack standing, it being indicted doesn't afford them standing to argue about matters that they have no right to complain about. And so he has bundled up a whole bunch of matters as they relate to other entities. Frankly, with respect to Hertz or any other entity, they can simply give us the documents we requested them. They could literally email them to us, as some of them will do. But the only entity and the only people that have a right to complain about that, and right now he's skipping over the fact that he has no right. He's asking you to jump right to, let's just get into the substance of the argument. And that is not the way that the law works. Mr. Steele is well aware of that. He is a very seasoned attorney. And he is attempting to escape that fact by just pushing forward and conflating all the arguments and making sure that they collapse into one mud pie. But Your Honor, I believe, and I'd ask that the court address that threshold matter before we get into anything else. And specifically, before we begin bringing assistant district attorneys in to talk about what could constitute work product and to discuss matters that have nothing to do, that are in no way matters that the defendant has a right to complain about.
All right, well, just give me a second, please. Did he do the process the way he did? I'm not going to ask anything about what happened in grand jury, except I have that recording that was given to us in discovery.
Is it discovery?
Yes. Okay. Will not ask anything about what occurred in a grand jury, except what was given to Mr. Williams in discovery by the state of Georgia. It's a recording.
Wes, do we have a copy of the motion to suppress? Yeah, that's what the motion was. Okay, I moved on the issue of the all right, I think I'm back on at this point in time. In terms of motion to quash the business records, I'm also going to grant the motion to quash the subpoenas, both subpoenas 1 and 2. The court is of the opinion that the relevancy of these particular records, but also they're protected by work product under 24-5-501. And for those reasons, I'm going to deny, I'm going to grant the state's motion to quash on those two subpoenas. All right, anything else?
Thank you, Your Honor.
All right. I have some proffers I need to deal with. Let's see, Mr. Where is he? Mr. Hoover?
I'm sorry, Your Honor, before we do that, I just want to bring the court's attention. Mr. Kendrick has voted to suppress statements on the record. We have a witness here, spoken to counsel. He doesn't intend to go forward on that motion.
He does not intend?
We were hoping we could release our witness. Who's going to answer that?
Yes, any objection, counsels?
No, just to be clear, we're not withdrawing the motion. We would just like to argue that on another time.
And your name again, I'm sorry.
Doug Weinstein, W-E-I-N-S-T-E-I-N.
Mr. Weinstein, what is your what's your client's name again?
Giovanni Kendrick.
I'm sorry, Your Honor, we're just hoping our witness might be able to go.
Well, you know, folks, I like to be able to accommodate everybody, but you saw what happened this morning, okay? We had a technology glitch that nobody could have foreseen, I should say, and we're kind of a little bit behind. So we're a little bit behind in terms of just being able to properly conduct court. So, what is your motion? Your motion is to suppress?
Yes, sir.
Could you give me just a few minutes and I can maybe have that motion heard since your witness is here?
No, Your Honor, I believe he doesn't want it heard today and we don't object to a continuance. So
Oh, okay, all right, so your motion is suppressed. All right, we're gonna, okay, all right, I understand.
Thank you, Your Honor.
I'm with you. Okay, yes.
Your Honor.
You give a mouse a cookie. What is it you want, Mr. Short?
Thank you, Your Honor. I just wanted to make sure that I respect the record. I know that you have not ruled on the
It's not your turn yet.
Well,
You jumping in front of Mr. Steele now?
no, I am not jumping in front of
Okay, all right. What is it you'd like to tell me?
Well, I filed the exact same motion that Mr. Steele filed
And your
regarding
client is, sir,
Stillwell.
Mr. Stillwell?
And that
Okay.
was filed on November 16th. And
The motion to dismiss the indictment
motion to dismiss the indictment.
and motion to suppress evidence. You wish to table yours at this point in time?
I have not heard you rule on the actual motion, just on the subpoenas. And I would just point out to Your Honor that our argument is not based on any Fourth Amendment violation that would require standing, but rather prosecutorial misconduct, which I believe as citizens of the United States, we all have standing to challenge. And Mr. Stillwell, who has been indicted and investigated in part by legally issued subpoenas.
I'm gonna deny the motion to dismiss the indictment, okay?
Okay, well, I just wanted to make sure it was on the record that I too have filed that motion and.
All right, I'm with you. Okay, all right. So to the extent that's been ruled upon, that's fine. Anything else?
Actually, Judge, just while we're here for the record.
Yes, Mr. Meneses.
I have failed to adopt the motion as ready, but I did want to respect the record that that's on me and that was effective, but I do want to orally also adopt Mr. Steele and Mr. Schultz's motion.
All right. Well, you probably should reduce that to writing, but Ms. Rosen wants to review, will include that in order, please, madam.
Yes, Your Honor.
Yeah, I'm gonna, in the motion to suppress and motion to quash, okay?
And Your Honor,
You can-
would you allow me to incorporate Mr. Steele's argument into the record on behalf of Mr. Steele as well, so I do not need to cite the same cases and,
Yes,
thank you.
so we'll include you as well. Okay, anybody else? All right. Okay, before I was interrupted by Mr. Sharp, Mr. Hoover.
Yes, Your Honor.
Okay, do you have the issue of the proffer that you'd like to complete at this point in time? I was going to ask you to complete that issue of the proffer And then also, if there's anybody else who we still need to deal with the issue of the proffer.
I'm not sure which proper.
Ms. Rosenwald, you want to address that, please?
Your Honor, I believe the court is referring to your continued, Mr. Hoover's continued representation of Mr. Someone after you were disqualified as to Mr. Blaylock, to see if Mr. Blaylock was on board with you continuing to represent Mr. Someone.
Well, Mr. Blaylock's attorney is here, so if the court wants to continue, we can at this point.
Where's Mr. Blaylock's attorney?
It's me, Attorney Justin Hill, Your Honor.
Is it Justin Hill?
Yes.
Okay.
And
And you are counsel for, I'm sorry, Mr. Hill, I apologize.
I'm sorry, can you say it one time?
You're counsel for whom, I'm sorry?
Mr. Blaylock.
Mr. Blaylock, okay, all right.
Demond Blaylock, yes.
All right, Mr. Rosenwald, do you have a copy of the proffer?
I can take a hold of.
Could you please, ma'am? I don't think I have it last year. Huh? Oh, yeah. We kind of jumped the gun a little bit, just to, so that myself and Ms. Weaver are in sync as to who is present today and who's representing whom. Could we just take roll call as to who's here? So we'll start out with my left, your right, gentlemen or ladies. If you're representing anybody, could you kind of state who you are representing, please? Okay, all right. All right. Okay. That wasn't right.
Adrian Love for the state, Your Honor,
Okay.
Deputy District Attorney.
Yes, ma'am.
John Floyd from the state.
Deputy District Attorney Simone Hilton for the state. Assistant District Attorney Lizzie Rosenwasser for the state.
Okay, all right. Now for the defense counsels and their clients. All right, we'll start off, Madam, I forget, and on the right side.
Chelsea Golden from Mouse Farley.
Thank you, Madam.
Anastasio Smedes for Mr. Mouse Farley.
David Bob, Shannon Stewart.
Max Shard for Shannon Stewart.
Jeffrey Williams.
And I'm Brian Steele. I'm also the honor representing.
Okay. All right, counsels in the back, anybody who's representing anybody here today, Madam? In the orange? Yeah. I'm sorry, one more time? Yes, ma'am.
Gina Bernard for David Myrick.
Michael Russ for Mr. Bear as well. Good afternoon, Sui shout out, I got Mr. Dorsey.
All right, continue to the center.
Doug Weinstein for Mr. Diamante Kendrick.
All right. Hold on, Mr. Harvey, I think it's you.
Mr. Nelson, along with Nicole Westmoreland, she is on Zoom, and you can see that she is on Zoom as well.
Yes, sir, thank you. All right.
Kimberly Williams for Mr. Ryan.
Thank you, madam.
Sean Hoover, friends on this one.
Okay,
Justin Hill for Demond Blaylock.
all right. Continue, madam.
Christy Gladden for Trontavia Stevens.
Thank you, madam. All right, anybody else to my left, your right? Okay, all right. Just want to make sure who was here along with clients today. All right, okay. Thank you very much, Council.
If I may, I apologize. I'm here on the platform, Tiambre Callan, on behalf of Mr. Khalif Adams.
Okay. All right, anybody else on our Zoom platform? I'm sorry that we had such difficulty with today. Anybody else? Is your client, Mr. Adams, on the platform as well?
He is not that I see, Your Honor.
Okay.
He's in the back row.
He's in the what?
He's in the back row.
He's here actually in court. He's in the gallery, madam.
Thank you, Your Honor.
Okay, all right. One more time, counsel, your name. I apologize, madam.
Tiambre Callan.
Well, and can you spell that for us, please?
Sure. First name is Tiambre, that's Teombre. Last name is Callan, Calland.
Okay. All right. Okay. All right. Okay. All right. So we're talking about profit. So Ms. Rosenwasser, do you have that?
Yes, Your Honor, I was able to locate a transcript from a previous hearing.
Okay, all right. So can we take care of Mr. Blaylock's proffer at this point in time?
Yes.
All right, let me go ahead. Mr. Blaylock, where are you, sir? Can I get you to raise your right hand for me, please, sir? Investigator, would you solemnly swear or affirm the evidence you'll give in the matter out here should be the truth, whole truth, nothing but the truth, so help you God so affirm?
Yes, sir.
All right, you put your hand down. Sir, we're just gonna ask you a series of questions just related to the proffer, nothing else. And then after that's done, I'll make a decision as to you and your counsel, okay? All right, Ms. Rosenwasser, if you go ahead and read that particular cover, he's already been sworn, so.
Sir, I recognize you're currently being represented by, I'm sorry, your name, sir.
Justin Hill.
By Mr. Justin Hill, is that correct? And sir, were you previously represented by Mr. Sean Hoover? Are you aware that Mr. Hoover is still representing your co-defendant, Mr. Antonio Sumlin? Okay. Now, have you been advised of a potential conflict between this attorney still representing Mr. Sumlin? No one has advised you of a potential conflict? So, yes, someone has spoken to you? Okay. Is that your attorney right now who's spoken to you about that? Okay, who spoke with you about that? Okay, did a woman, Ms. Rivera, speak to you? I'm sorry, sir, I'm being confusing. Has another attorney, anyone other than these two guys, ever come and talk to you about this case? Okay, was it an attorney as far as you know? Okay. Did she explain to you that there is a potential conflict with the agency? Okay. Are you aware of, so you are aware of that conflict? Okay. You understand that you have had, even if you have had meetings with this counsel, Mr. Hoover, you still have no objection to him continuing to represent your co-defendant? Okay. And you met with someone else independently outside the presence of Hoover or your current counsel about a potential conflict of interest, is that correct? Okay. And you have stated that you waive any potential conflict and you wish for this gentleman to remain your counsel and you waive any conflict with your co-defendant being represented by Mr. Hoover. Okay. And has anyone promised you, threatened you with anything, coerced you, or in other ways forced you to consent to this? Okay. Do you waive any other it could be used in your co-defendant's defense. You don't waive that? Try again. Do you understand that if you went to trial, anything that he learned when he was representing you, Mr. Hoover, could be used to help your co-defendant with yourself? Okay. Do you still waive any conflict? Okay. Your Honor, I believe that confirms any conflict.
Okay, Mr. Blaylock, did you, before signing, have the opportunity to talk to counsel to your satisfaction? Yes? Okay. And you give this waiver freely and voluntarily, your own decision to waive any potential conflict in this case? Yes. All right. Do you have any other questions about this particular conflict you want to ask me? Okay, all right, I'm going to go ahead and Mr. Okay. All right, thank you, sir.
I believe that covers all the waivers.
Thank you. Mr. Hoover, Mr. Plead, what is your recommendation?
Your Honor, at one point he had an attorney. I'm not sure if that attorney was withdrawn. It was for Larry Hemingway. So I don't know if she is for Larry Hemingway. I don't know if she's withdrawn. I know he had an attorney when I was doing a lot of motion service last month.
From my understanding, Ms. Hemingway still represents Mr. Fleetwood. I'll definitely double check.
I'm sorry, it's not. She works in the same office.
Yeah, I think that was the call.
I'm not sure if she's formally withdrawn though yet, so that may be why this has arisen.
So, Ms. Bernard, can we do, just a housekeeping matter? Can you ask her to, formally, if she's not done so, withdraw? And I will ask Mr. Hoover to go ahead and, continue that process of representation, okay?
Yes, sir.
Okay, thank you, ma'am. All right, so Mr. Hoover, you'll take care of that and we'll do this?
Yes, Your Honor.
Okay, all right. Mr. Arnold. Where is Mr. Arnold? Oh, good afternoon, sir. Who's your attorney?
Ashley Merchant.
Ashley Merchant. Okay, okay, all right. All right, sir. We're gonna go ahead and, I believe that, she has something else to do this afternoon, but we've been in touch with her, okay? So just give me a second. All right, Mr. Beebe?
He's still in the call, sir.
Yeah, is he on the?
No, he's not on the platform.
Who is his lawyer?
Mr. Partridge has to go to Upson County for another trial today.
Okay, all right. All right, Mr. Epinger. Mr. Epinger, you ready to have,
He's right here. Right here.
Oh, thank you, sir. I apologize. Okay, Mr. Evans, who do you represent by, sir?
Eric Johnson.
Eric Johnson.
There was no communication.
Okay, all right. All right.
You know, I had my office reach out to Mr. Johnson, and we will make sure it will be.
Thank you, sir. Appreciate it. All right, and this is McMullen. Mr. McMullen. Who? I'm sorry.
Amanda Young. I believe
She withdrew, and Attorney W.B. Green will be representing her moving forward. I want to say yes, but I have not double checked myself.
Who is Mr. Montalban's attorney?
W.B. Green.
Do we have a withdrawal? Who is his prior counsel?
Amanda Young.
Amanda Young?
Yes.
Do we have a withdrawal from her?
Yes, the court did.
Okay, do we have an entry with Mr. Green?
We do not.
Mr. Hoover?
I'll make sure it gets on your honor.
Okay, he is doing it. Four of that, looks like Mr. Green entered that, it's on four of that.
Okay, perfect.
Okay, all right. Yeah. Mr. McMullen, I'm gonna go ahead and since your counsel's not here, we do have some, he'll talk with you, but I'm gonna release you at this point in time, okay? Mr. Evans. Mr. Evans, I'll release you at this point in time as well, since your lawyer is not here, Mr. Johnson's not here as well. Mr. Beebe, where are you? Not here. He's not here. Oh, Mr. Beebe's not here, okay. Thank you.
What happened, Kent? What happened? What I missed?
Man, from what I heard, it sounded like they letting somebody go, but I can't see. You took the screen off. I was trying to see if they was trying to let one of the other co-defendants off or something. Yeah. Somebody getting let go.
They're trying to release a motherfucker, huh?
That's
What
why I was
y'all
like,
see,
man,
man, in
did
the
your
chat? What
boy,
y'all
did he
hear,
plea
man?
out too soon?
Oh, you talking about the other boy?
Huh?
Yeah, I don't know. I
Like,
don't know.
man, did he plea out too soon? If he probably would have waited just a little bit longer. They letting somebody go.
Well, they want him to say, like, I did hear him say that, you know, that's a rap organization and a gang organization. So that, I'm telling you, everybody's not going free. We all
I don't
agreeing
think
to
that.
that. I mean, we know that
Right.
the world loves Thug and everything, you know.
Right.
Everybody's not gonna go free. You know, you got some dudes that'll take the 5 years, 10 years. Maybe they're offered some money. You know, maybe you know, they take the rap. You know, who knows? It's probably a whole lot that's going in all this.
And then too,
Let me see what the lead attorney talking about.
Oh, okay.
He's usually on top of it.
Listen, the mods got you, Gail got you, BLJ got you, Sinji. Like, we've got some strong moderators. They've been dropping links for the last 7 to 8 hours.
This is so crazy, man.
Thank you to the moderators that were here from start to
Oh, it
finish.
is in there. It's in there, right? I can't tell if it's in there or not. Is it in the description or no? Let me check.
I'll look too.
Yeah, it's in there. So you can come to the meetup, and it says the lead attorney's live streaming course. All right, so just click that, teachable.com. It's right there. I will paste it in the, that's not going to work, really. And you can see how much I make, guys. So they're having audio problems. This is not our audio, of course. If you want to see how much I make, I'm going to pin it to the top. Everybody watch this video. YouTubers do not tell you this. All right, listen, I'm gonna pin this video. If you want to know how much the lead attorney makes,
this guy's crazy.
Watch the video. Let me pin it. All right.
While you do that, shout out to Koi, who sends me a $5 cash app. He says 7th power times infinity. Thank you so much, Koi.
Shout out to Koi. Shout out to Koi. Excellent, excellent, excellent. So Brian Steele is up at the podium again, talking, trying to figure out what is going on here.
I wonder if they're going to go for his motions today. That's what I was hoping we can end this with.
Yeah, that would be fantastic. That would absolutely be fantastic. But it looks like the judge might reserve a ruling on that and then might pick that up at a later date.
Yeah, it's getting late. I don't think they're going to.
Because he said that they're going to reconvene Monday or Tuesday.
Yeah, it looks like a lot of the defendants in the back cleared out too.
Yeah, so we'll see how it goes. At any rate, guys, they're just doing, I mean, let's stick around a little bit, see if they get the act together since he is, but it looks like they're kind of checking out. But since Brian is talking and the prosecutors are talking. But if you want the code, it's in the description. Lala trying to get this money. Some of y'all be sleeping on this courses. Lala is trying to get this money.
Do it, Lala.
Right. And again, there's no dress code for the meetup, guys. No dress code. If you want to do it up and wear a suit, you can do that. Your boy is not wearing a suit. You best believe that. All right. But if you want to do it up, if you're, styled up, imaged up, you can absolutely do it. We just gonna fellowship. We're gonna eat. We're gonna feast. We're just gonna have fun, man. Says, are y'all gonna cover the Meg? And I've been trying not to cover this case, but y'all are just like, please cover it. So I know it. Yeah, we might have to do it. All right, guys. So yeah, that's the code. The code is in the description. All right, guys, we've been going for 8 hours. And we have the mastermind meetup, guys. If you want to
They
become
covered
a
it for the
member,
whole time. They crazy.
you can join the mastermind. We meet every Thursday and Sunday over Zoom. We just had O'Shea Duke Jackson come in as a guest speaker. We've had MTR, Mediocre Tutorials and Reviews, come in. We have had Poor Man's Podcast come in. We had Melanie King. She came in. Just Pearly Things is coming at the end of the month. I'm getting you the biggest YouTubers that you guys do not have access to. I have access to these people. You do not, but I am bringing them here to you. All right. AV, shout your channel out again for us.
Yes, you guys can find me at AV to the 7th power here on YouTube for legal content and lifestyle stuff.
Excellent. So thank you so much, AV. Her Cash App is the same thing, and her Instagram is the same thing. Any closing words for your folks?
No, this was a really interesting day. I hope you guys took a lot away from it. Just, you know, the stuff that you see on Law and Order or, you know, Law and Crime even, it's a little bit different from what you see in person. So we were happy to give you guys content.
Yes.
Found guilty of that correctly under sentence?
That's right.
All right, what's your pleasure, sir? I mean, I know that you have a few motions that are pending, but what's your pleasure on that? Do you wish to talk to the state, or what do you think?
You know, we are in discussion with the state. I hope that an offer that I'm applying for the state will come through. At this point, I'm not at the benefit of talking to my client because he's been moved. Hopefully, once I get an offer, I can present it to him. Otherwise, we'll be ready to go forward with motions on that.
Okay,
So, no, he will not be here on Monday. He's currently probably in.
All right, guys. They're just doing they're doing random.
It's out of there. You dig? They doing dates. It's out of there. They probably resume Monday. You know, hey, this is some slippery shit, though. You know, you see what you can get yourself into. You think the lifestyle. You know, everybody wants to be a part of the lifestyle and everything. You know, I remember the song "Lifestyle" and all. You know,
right.
You came from the bottom, and you know, you remember, you came from the bottom. So when you get at a level, that's when you got to take some clarity, take some time, and get some clarity. You know, and really observe your surroundings, the people that you're hanging around. I think that's playing a big part. You know, all these tough guys, and you know, these, you know,
got to move different.
Yeah, definitely.
Yeah. So somebody in the crew got let go. I mean, I don't think he's let go like scot-free or cleared of all charges, but as far as holding him, you know, they let him go for now. You know, so it's everything is still ongoing.
Are you talking about the Gunna guy?
No, if I'm not mistaken, it's another guy in the crew because they were they had a bunch of attorneys, you know, naming themselves off of who was representing who. So I didn't get to physically see that, but I'm just listening. So it was a lot of, you know, you told me like if it's a crew of guys or whatever, everybody got the individual attorneys. So somebody in there got got released for now. So
I'm have to go back and check that out. That's crazy.
Yeah.
That's crazy.
If I'm not mistaken, if I heard that correctly, yeah, somebody got released. I don't know if it was just not enough on him or just it's not, you know, they have no more to keep him. But, so yeah, it's definitely gonna be an interesting trial, man. But as far as we know, Thug is still in there.
Yep, he got to come back and fight another day. You dig?
Yeah, his lawyer, man, he represented him. I give him that. Got one thing kind of dismissed. I don't know if that was a charge with the whole property thing, the phone and all that. So he got that out the way.
Hell yeah. Well, it's your boy, Dr. Hood. You know what I'm saying? We are the Splash. Get up in there. get some of this coverage on here, man. I had a show I was gonna do, but I was like, you know what? Let me just get the easy content out the way, and I got a real good show. I might even fire it up tonight, maybe later on, maybe tomorrow. You know, I don't know. You know what I'm saying? We got some subject matter, all of that good stuff. You know what I'm saying? Appreciate everybody that came through. Hit the like and subscribe, all of that. You know what I'm saying? I didn't have no music coming in, but we're going to have something coming out, man. Peace.
Peace.
I'm trying to get these millies, so I'm taking all these risks. Try to holler at your bitch, but she wasn't talking shit. Try to do it right, but it just wasn't making sense. Gotta hustle every day, cause I gotta pay this rent. I'm trying to get these millies, so I'm taking all these risks. Try to holler at your bitch, but she wasn't talking shit. Try to do it right, but it just wasn't making sense. Gotta hustle every day, cause I gotta pay this rent. Wake up, go get it, handle your business. You could work a 9 to 5, it ain't no difference. I keep trying, if I lose, man, I'm so different. The Lord wired me different, man, I'm so gifted. I got knocked on my ass and I tried again. I had to pull a couple strings like a violin. I got little discouraged, but I tried again. They don't support what you doing, they are not your friends. I'm just keeping it real, or that Gunna's keep it a buck. Man, you gotta keep faith even when you down on your luck. Bad transmission, going nowhere, I was stuck. I had to bounce back just like crack, whipping it up. I'm trying to get these millies, so I'm taking all these risks. Try to holler at your bitch, but she wasn't talking shit. Try to do it right, but it just wasn't making sense. Gotta hustle every day, cause I gotta pay this rent. I'm trying to get these millies, so I'm taking all these risks. Try to holler at your bitch, but she wasn't talking shit. Try to do it right, but it just wasn't making sense. Gotta hustle every day, cause I gotta pay this rent. I try to make money every minute, every second. Hungry for the money, had to come back for seconds. Just touchdown with the pack, it's a blessing. Cause if the pack don't touch down, you'll be stressing. And I try to stay connected like Wi-Fi. Finesse you 2 times, but I ain't from mob ties. I'm so wrapped around this money like it's hog tied. I'ma keep chasing that till we all die. I'm trying to be the best that I can. I kept on going when I didn't think I can. Didn't think I could ever be a better man. I try, I swear I'm looking for a better plan. Yeah, I'm trying to get these millies, so I'm taking all these risks. Try to holler at your bitch, but she wasn't talking shit. Try to do it right, but it just wasn't making sense. Gotta hustle every day, cause I gotta pay this rent. I'm trying to get these millies, so I'm taking all these risks. Try to holler at your bitch, but she wasn't talking shit. Try to do it right, but it just wasn't making sense. Gotta hustle every day, cause I gotta pay this rent.